All right, we should be back at it. We should be good to go. Looking all crispy and clean on the screen. Welcome, y'all. Welcome back to another YouTube live stream and another episode of the ClassE Morning Show. I'm your host, ClassE, of patreon.com/ClassEbeats. By the way, the link is in the description as well as in the pinned comment in the chat. If y'all could do me a favor, drop the 1 in the chat if you can hear me. Drop a 1 in the chat if you can see. We should be good to go. Shout out to everybody who's in here. I gotta say what's up to the people in the building before we get started. And happy Friday to y'all, by the way. We got my awesome, amazing Amy is in the building. Shout out to Amy up in here. Les Cleaver is in the building as well. We got Nancy Matherson. Good morning, Nancy M. Slim Life is in here. Good morning. Libby22 SC Girl is in the building as well as the amazing Shauna. Shout out to Shauna. I appreciate y'all for being here. I know we're starting a little bit early this morning. Y'all probably like, what's going on? Well, we had to end the show a little bit early yesterday because we had some other things going on yesterday afternoon. So we are here. We're going to finish up the testimony from the medical examiner and see what else took place after the day ended officially, unofficially. And we had some back and forth between Alessi and Judge Bev. It was getting fiery up in there. So we'll get into it here in a second. If y'all could do me a favor on your way in, make sure you like the video. Not only is it free, not only does it take less than a second to do, but it really does help the channel continue to grow and lets the algorithm know you guys are enjoying the show, and it shares the video and the channel out with more people. So if y'all could do that, I would greatly appreciate it. We've already got 600 of y'all that like the video. Goodness. Absolutely amazing. Y'all have been doing such an amazing job with liking the video. So thank y'all for that. It helps out so much. All right, let me see. We've got a couple super chats in here. So I want to make sure I say a special thank you to everyone that's in here this morning, giving some super chats early. My dog, Les Cleaver, is in the building. Shout out to Les Cleaver. What does he say? He says, God bless you all with the 10 bomb. Love one another, respect one another, honor one another always. Thank God it's Friday. Have a great weekend. Best YouTube channel ever. Shout out to Les Cleaver. My love to all of you. See you all through the day. Appreciate you, Les. Hope you have a great day at work, and thanks for stopping by first thing this morning. We've got Amy in here with the banana. It's a banana-versary. Happy banana-versary, Amy. Boy, I wish I had time to tell y'all this story about the banana-versary, but it's just too much. Happy banana-versary, Amy. In the community for over a year plus now. It's going crazy, and so glad you're here. So glad you're a part of my life, baby. Thank you for everything you've done since day one you came into this community, since day one you came here, and it's been so amazing. So I appreciate you. I love you. I thank you for everything that you've done on the channel, off the channel. You know how much I appreciate you, Amy. Thank you so much. Happy anniversary. And then she's also gifting 5 memberships. If you got a membership from Amy, make sure you say thank you. So much of what y'all see going on has been a result of the hard work that Amy puts into the channel and to the community as well. So big shout out to Amy. All right, I think I got all the super chats. Actually, that's not true because I saw somebody over on the PayPal, I believe. Let me double check this and make sure. Hold on a second. Hold on. I know I saw it. I'm not crazy. There we go. Slim Life, New Jersey's in the building. She says, good morning, ClassE, Amy, and the amazing CEB family. It's Friday. Let's get it. I hope everyone has an amazing weekend. Thank you guys for all you do, making it possible to watch these awesome content you put out daily. Love, Slim Life. Thank you, Slim Life, for the support. We've got Brenda is in here as well. Shout out to Brenda Bonamy. Good to see you. F Casola's in here. Wendy W's in here. Good morning, y'all. All right, we're gonna go ahead and get into the video and into the court proceedings we missed from yesterday. So again, if you haven't liked the video on your way in, please make sure y'all do that. Let's go ahead and see what the good doctor has to say. Dr. Scorty Bello.
Please be seated. Court is in session.
As Alessi likes to call her. Thank you for the 20 bomb over on
All right, Mr. Alessi, you can continue where you left off.
Thank you, Your Honor. May I reapproach the witness?
Yes.
Dr. Scorty Bello, you have in front of you, which has been marked for identification as MN
and you were discussing that, do you recognize that document since it sort of started over to reorient the jury? You recognize that?
I recognize what it is, yes.
And the sound's gonna
It is
get
a
better,
picture
y'all. It's
of
not
a
me.
stomach, of the mucosa of a stomach with multiple hemorrhages.
And does that
Good morning, Danny.
exhibit fairly and accurately depict a stomach with what you have referred to as multiple ulcers?
Yes.
Your Honor, I offer that into evidence.
I definitely agree as a child.
I'll, you know what, if I can use it as a chalk
Yes, you
publication.
can.
Yeah, that's what I'll do, Your Honor. Thank you, Mr. President.
So you can have it displayed.
Thank you. And again, I'll leave this hard copy with the court reporter, and we'll use the
Oh, so it's not in evidence?
It is not.
It's marked for
Mark,
identification?
yes, marked for identification, and we are with it. Mr. Wolf? Dr. Scorti-Bello, is that the depiction that you were just describing at your witness stand?
Yes.
And could you please, with the laser pointer, state what you see in this depiction?
So this is a stomach. This
Thankfully,
is
they're
the
not showing
mucosa,
it.
the folds of the stomach. They're not very folded in this particular picture.
Hey!
You can see these distinct areas that are that have a darker coloration. That's blood. These are hemorrhages.
And to be clear, this is not the stomach of Mr. O'Keefe. This is a medical reference depiction to sort of generic, or some other
there we
depiction
go.
other than Mr. O'Keefe's stomach, correct?
Correct.
If we could, with Your Honor's permission, Mr. Wolk, put side by side this chalk with what is in evidence as the actual gastric mucosa of Mr. O'Keefe.
The objection sustained.
Could we, with Your Honor's permission, publish simply Mr. O'Keefe's
Yes.
gastric mucosa?
Yes.
There you go.
Isn't it correct, Dr. Scorti-Bello, that there are much less dark spots in this depiction of the gastric mucosa than there were in the chalk that we just displayed? In other words, that green depiction of what I'll just refer to as a generic stomach. Is that correct?
That is correct.
So, you can take that down, Mr. Wolf. Isn't it correct that for hypothermia in the presence of Wisniewski's ulcers or spots, that you have to have a predominance of the stomach covered by the spots for them to be Wisniewski ulcers?
I think there's different levels and different grades.
In hypothermia, particularly death from hypothermia, wouldn't you expect to see a predominance of those ulcers, meaning they take up most of the stomach lining? Isn't that what you would expect to see?
Not always. I have seen that. I have also seen cases with much fewer spots, as you refer to them.
But isn't the majority of the cases that you have seen where someone has actually died from hypothermia that the ulcers predominate, take up greater than 50% of the stomach?
Yes.
And what percentage of the, and I'm trying to avoid putting it up again, so what percentage of the gastric mucosa of Mr. O'Keefe would you estimate is taken up by the ulcers that you have identified?
I would say somewhere between 10 and 15%.
Just 10 and 15%. Thank you. Now, if we could look to the issue of continuing with hypothermia. Let's go to frostbite. Did you
Oh, did he have frostbite?
note any evidence of frostbite on the deceased, Mr. O'Keefe?
No, I did not.
Do you know what the weather conditions were in Canton, New York on the early mornings? I'm sorry, I keep saying Canton, New York. My apologies.
There's a Canton, New York. I didn't know that.
Do you know the weather conditions in Canton, Massachusetts, starting at midnight on January 29th, 2022, going through 6 a.m. on January 29th, 2022?
It was very cold. There was a blizzard coming.
They called it a nor'easter, right?
Correct.
And when you say very cold, in addition to very cold, do you recall whether there were gusty winds?
I believe so.
And do you understand that when there's a very cold temperature in Fahrenheit and you add gusty winds, that is called, when you apply the two together, that's called wind chill, right?
Correct.
And with wind chill, doesn't the phenomenon of wind chill mean that the wind combined with the temperature brings the actual temperature down, and in addition to bringing it down, temperature in a wind chill calculation, it also has a physical effect on the body, correct? Wind chill. Doesn't wind chill also cause greater effects than if there was no wind?
Correct.
So in medical terms, the wind synergizes with the temperature and exacerbates the effect on a human.
Correct.
And with a wind chill, isn't it correct that you would have a greater chance of frostbite than if there was no wind chill effect at all?
Yes.
So, you saw no signs of frostbite on Mr. O'Keefe, correct?
At the time of my examination and at the time of autopsy, no, I did not.
Did you see frostbite at any other time with regard to Mr. O'Keefe?
I only examined him at the time of autopsy.
So, at the only time you examined him, which is at the time of autopsy, you had zero signs of frostbite, correct?
Correct.
Dr.
Interesting.
Bell, now that you have gone through this part of your examination here today, would you like to amend in any way your opinions as to whether hypothermia was any cause of the death of Mr. O'Keefe?
No, I don't. I still believe that there were hypothermic signs.
Hypothermic signs, correct?
Interesting.
I'd like to move to another topic area, please. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you?
No, I did not.
Oh, hold on a second. Hold on. We got to run this back. This is an interesting line of questioning. So now we're talking about how the injuries were sustained, specifically when it comes to a motor vehicle. This is going to be good.
Examination here today. Would you like to amend in any way your opinion
This is going to be good.
as to whether hypothermia was any cause of the death of Mr. O'Keefe?
No, I don't. I still believe that there were hypothermic signs.
Hypothermic signs, correct?
Yes.
Here we go.
I'd like to move to another topic area, please. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you?
No, I did not.
Why?
In fact, there were no injuries consistent with a motor vehicle impact on Mr. O'Keefe, correct?
Sustained.
Did you evaluate it all in your autopsy whether Mr. O'Keefe had any injuries consistent with a motor vehicle accident?
I'll allow that.
Allow it. Great question.
Yes, I did examine his lower extremities. That is protocol in
And?
any case of suspected impact with a motor vehicle. So I did examine his legs, and I did not see any evidence of an impact site.
Uh-oh. No impact? No car accident? What are we doing here? So how did he sustain those injuries, good doctor? Let's
And
see.
can you elaborate to the jury what you mean by no evidence of an impact site?
I'm going to sustain that objection.
What?
What do you mean
Why?
in your answer, no evidence of impact injuries?
I'll allow that.
Yeah, allow it, please.
What I look for is some sort of bruise, either on the outside of the leg or bleeding on the inside after the skin is reflected in the soft tissues, or any fracture of the bones of the legs. I did not observe those things.
That was going to be my question. You did not observe any of those things, correct?
Correct.
Wow. This is from their own guys. This is from their own medical examiner. What are we doing here? He was not in a motor vehicle accident. I guess it's possible he could have been, but she didn't see any signs of that. What are we doing here? This is insane. Amazing.
I'd like to turn to, please,
Wow.
the face of the decedent in your analysis that you discussed on direct examination of that area of the decedent.
That was a great question.
You talked about ecchymosis. You recall that?
Yes.
In medical literature, there's a synonym for ecchymosis. It's sometimes referred to as raccoon eyes. Is that correct? Ecchymosis doesn't cause a laceration to an eyelid, does it?
No.
Ecchymosis does not cause a laceration to a nose, does it?
Nope.
There was an abrasion on the nose, but no, the answer is no.
Correct. So ecchymosis doesn't cause a laceration to the nose. Correct?
No,
Correct.
it does not.
Did your report at all evaluate whether there was any significance of the laceration to the eyelid that you spoke about in your direct testimony?
What do you mean?
Other than just noting that there was a laceration to the eyelid, did your report at all evaluate the potential significance, if any, of that laceration to the eyelid?
I noted it and photographed it, and it was part of the totality of the blunt impact injuries that I noted on both the face and the head.
So he got punched? How did they get there, good doctor?
That the laceration to the eyelid could be caused by a blunt impact injury?
A laceration, by definition, is a blunt impact injury.
Do you believe the eyelid laceration was caused by a blunt impact injury from falling backwards and hitting one's head?
Not from falling backwards and hitting one's head, but that area at some point came in contact with a blunt object or surface.
Okay, if I could follow up on that, please. So you agree that if a person falls and hits the back of their head, that they cannot sustain an eyelid injury, is that correct?
As a
Correct.
result of that, correct.
And if somebody falls backward and hits their head, they can't sustain, from that impact in the back of the head, a laceration to the nose, correct?
Correct.
So if we could, Mr. Wolk, and with Your Honor's permission, publish which is already in evidence, which are depictions. Let's start out with, please, the laceration to the right eyelid. And
Man, I hope
Dr.
we get to see
Scorti-Bello,
this.
is this the laceration to the right eyelid that we've been talking about of Mr. O'Keefe?
Yes, it did. Yes, it is.
They're
And
not going
that
to show
injury
it. Dang.
could not be caused by a fall backwards and one hitting their head, correct?
No.
I'm sorry, we'll just need, and then I'm going to repeat the question. Can you state your answer again? Let me repeat. That injury to the right eyelid, that laceration, could not be caused by someone falling backwards and hitting their head, correct?
Correct.
Yep.
Bear with me one moment, Your Honor. May I approach, Your Honor?
Yes. Show Mr. Brennan.
She said, show my man. Show my man what you about to put up
Your
here.
Honor, I erroneously assumed that that picture was in evidence, and I would like to now properly lay the foundation if I could. Dr. Scorti-Bello, you see what's in front of you. Can we mark this?
So, Mr. Brennan, are you objecting to that coming into evidence? Okay, so let's just put it in evidence.
165.
Thank you.
This is amazing. I can't wait to see how the rest of this questioning goes.
Yeah, Your Honor.
Yes.
Dr. Scorti-Bello, I place before you what is in evidence now is 165. And Your Honor, may I have Mr. Wolk publish
Yes.
165? Thank you, Mr. Wolk. So, Dr. Scorti-Bello, that laceration to the right eyelid could not be caused by a fall backwards where someone hits the back of the head, correct?
Correct.
So that injury you've called, what do you label that category? Traumatic, did you use that phraseology?
Blunt
Blunt
impact.
impact. So that's a blunt, in your opinion, that's a blunt impact injury, correct?
Correct.
So is it correct that that injury had to occur in some manner other than falling backwards and hitting one's head?
Yes.
And is that injury consistent or inconsistent with a punch?
I'll allow it.
Oh, she allowed it.
Could be consistent.
Oh, man. We called it. Oh, my goodness. Dr. Scorti-Bello just said, I think he may have been punched. It's possible. That injury is consistent with someone who has been punched. Guys, this is major for the defense. Major reasonable doubt, period. I don't even want to talk about what happened. Who punched him, why they punched him, where they punched him. That's going to have to be a different trial for another day if the O'Keefe family decides to pursue this once Karen Reed's acquitted. But this is, oh my goodness, embarrassing. No
If
wonder
we,
he objected.
Could Mr. Wolk have the laceration to the nose?
Wow.
I'm sorry, hold off on a moment.
Peter, you might want to sit this one out, brother. This witness is not for you.
Your Honor,
Listen, and again, we're looking at it as a legal side. I know we'd like to analyze, but think about this as a juror. That's how you guys have to think about this. As someone who is a juror, he has these injuries that are consistent with someone who may have been punched. You think so? Now we're saying Karen Reed punched him too? Like, how much did she do? Was she that mad? She punched him, and then somehow she smashed him with a wine glass, and then she backed over him at 20-something miles an hour. Man,
Stop the cap.
come on. This is amazing.
Your Honor, Mr. Brennan has agreed to stipulate this going
Okay,
to
so like we can mark it.
Mock it. Mock it.
166.
Oh, thank you.
Wow.
May I, Your Honor?
Yes.
Thank you. Dr. Scorti-Bello, I have put before you what is in evidence is 166, and Your Honor may, Mr. Wolf, publish.
Yes.
Thank you.
Amazing.
Dr. Scorti-Bello, does that exhibit fairly and accurately depict the laceration to the nose of Mr. O'Keefe?
Yeah, it's an abrasion. I described it as an abrasion, as a scrape.
So you would classify that as a scrape?
Yes.
That scrape could not be caused by someone falling backwards and hitting the back of their head, could it?
Not by a
Correct.
single event, no.
You can take that down, Mr. Wolf.
These witnesses are just falling down one by one by one.
On
It's
your
crazy
direct
to see.
testimony, you talked about injuries to the right arm of Mr. O'Keefe. Do you recall that?
Yes, I do.
And is it correct that you, in your autopsy report, did not determine the cause of those wounds to Mr. O'Keefe's right arm?
That's correct.
With Your Honor's permission, I would like to
This is amazing. Shout out to Slim Life. Appreciate that.
Your Honor, Mr. Brennan has agreed to stipulate into evidence these two photographs. May I please have them
Yes.
marked as next evidence?
Wow.
Exhibits 167 and 168.
Thank you.
I'm going to do the same thing, if I may, Dr. Scordy-Bell. I'm going to leave these with you, but I'm also going to leave the court's permission to have them published.
Okay.
To whatever one best allow you to answer the question. Your Honor, may I have Mr. Wolf publish those two? Thank you. With regard to what is on the screen, am I correct that you noted these injuries to these wounds to Mr. O'Keefe
Oh,
in
now
your
we're getting into
autopsy
the
report?
dog bites.
Yes,
And am I correct that you noted that there was a pattern
Dog bites.
to those wounds?
correct.
And although you noted there was a pattern to the wounds, you were not able to determine the cause of those patterned wounds. Is that correct?
That's correct.
Are those injuries consistent with a dog bite?
Overruled.
Based on her answer to the last question, ask something else.
What?
Ask another question, sustain.
Why was that sustained? It's her job.
Can you identify any cause of those injuries that would be consistent with what is depicted on the screen? Objection.
So, can you answer that, doctor?
I cannot.
You can take that down, Mr. Wolf. Thank you.
This is amazing.
Do you recall discussing at all on your direct examination? Well, let me ask it this way. Did you evaluate at all in your autopsy a gray hoodie sweatshirt of Mr. O'Keefe?
No, I did not.
So, were you aware that there was clothing associated with Mr. O'Keefe when he came as part of the autopsy?
He did not have any clothing that came to us. The clothing was removed at the hospital and was packaged and I believe submitted as evidence.
So the clothing of Mr. O'Keefe, a t-shirt or a hoodie, didn't make its way to you?
No?
What was the question? Hold on, I missed it. Let's rewind this.
No?
So the clothing of Mr. O'Keefe, a t-shirt or a hoodie, didn't make its way to you?
No?
So she didn't get the clothing. Okay, so he said, so the clothing, the t-shirt didn't make its way to you? She said, no. Leading? I don't know how that's leading. So I guess would it be, have you observed have you done autopsies in the past where the deceased has been, I don't know. Yeah. How would you walk down that path? That's a tough one. So I don't know. Maybe it is leading. You're probably right, Melody. Have you observed?
You were unable to reach a determination
It's tough.
as
How would
to
you ask
the
that
manner
question?
of death of Mr. O'Keefe, correct?
That is correct.
So you have doubts about the manner of death of Mr. O'Keefe, and you consider those doubts reasonable?
Object.
Sustain. Sustain.
You were not able to reach a determination as to the manner of death of Mr. O'Keefe, correct?
Correct.
And manner of death, as you've testified, includes the circumstances surrounding death in addition to the medical analysis that you performed. Okay.
I'm sustaining it, asked and answered.
They need to get these mics right.
Thank you for answering my questions, Dr. Squirty Bell.
You're welcome.
Amazing. Absolutely amazing. What do y'all think? What do y'all think about this? This is huge. Absolutely huge. Because think about it, right? If you have a cut on your eye that's consistent and could possibly be, or is something that looks like it came from a punch, then you have blunt force trauma to the back of your head. What does that say to you? Punch, fall back, blunt force trauma. It's not. And you're telling me Karen Reed did that? Boy, man.
Stop the cap.
This is a great witness for the defense. Again, looking at this as a juror, I believe innocent until proven guilty. Y'all know that on this channel. But looking at this as someone who may be and could possibly be on the jury for a case like this, it seems pretty straightforward. I'm not seeing anything so far that points to Karen Reed's guilt other than she was crazy and she was having a back and forth with John. But there is nothing that shows me here she was the one that killed John. Y'all have to let me know what you think about this. This is crazy. We're going to keep going with the rest of this testimony. Shout out to the gang in here. Let me read a couple super chats. This is wild. I'm kind of sad that we missed this yesterday. We've got Virginia Wiley in the building. Says, good morning, Classy Beats and family. Happy Friday. Make today and this weekend great on purpose. Sending love and prayers. Thank you so much for the 5 bomb. We've got Teflon Don in here. He says Tiffany Henyard versus Fannie Pack Willis.
Stop the cap.
Round 1 fight. Again, who will win? Oof. That's tough. I would have to say Fannie Willis probably. Because Tiffany Henyard, she's just being reckless. Fannie Willis is being something else I won't say. CPE is up in here with the 5 bomb as well. Says happy Friday, CEB family. Have a wonderful weekend with the family and friends and hope to see everyone back again next week. Yeah, we've still got a long way to go. We got about 6-7 of them hours we're going to be sitting here and watching this trial. So make sure y'all stay locked in. Thank you to everyone that's liked the video so far. If you haven't liked the video yet, please make sure that you do that. Let's go ahead and get into the rest of this testimony. We've got redirect here. Let's see if Brendan can recover.
Doctor, how many autopsies have you performed in your professional career?
At this point, more than 1,200.
When the person is brought to you, are they usually clothed?
It depends on the circumstances. If a person comes directly from their residence, they may or may not be clothed. If the person comes from a hospital where they went first for treatment, many times the person is unclothed. They may be wearing a hospital gown, but in most cases that clothing has already been removed.
If that clothing has already been processed, is it common that it would be brought to you for inspection?
Sustained is to the point.
Is
Objection, Your
clothing
Honor.
that is not accompanying the person's body commonly brought to you for observation?
So let's move on. Or ask it.
Let's move on.
You were asked questions about your opinions relative to spots in the organs of Mr. O'Keefe. And
Guys, I'm playing this at 1.2 speed. A spoiler alert. I'm playing. What? Brandon, give it up, man. Give it up. Let's let it go. It's over. It's over. We're done. I'm playing this at 1.2 0.2 speed. He said, which, I, perfect with the, oh, get it together, man. Dang. He's
Is clothing
struggling.
that
This is
not
redirect. You
accompanying
got to
the
be
person's
ready.
body
Let's go.
Commonly brought to you for observation.
Objection, Your Honor.
So let's move on.
Objection, Your Honor. I love how he says that.
You were asked questions about your
Oh, man.
opinions relative to spots in the organs of Mr. O'Keefe. And you were asked about part of your statement in the grand jury. When you provide statements, is it
Oh my
important to
gosh.
have the statement in context to understand it?
Yes.
Is it important to have a complete statement rather than just part of a statement?
Give it up, man.
Yes.
Let it
When you
go.
were asked the question that counsel asked you, do you remember that grand jury testimony you gave?
Let it go, man.
I remember it was a long time ago.
Okay.
But I do remember most of it.
Do you remember when he read part of your answer? It was in response to a grand juror's question.
Yes.
And he read part to you, right, I understand your question, and my answer is that I don't know, but given the environment, so if the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. Do you remember that?
Objection, Your Honor.
Objection, Your Honor.
The doctor can answer that
Do you remember Attorney Alisi read you that part of your statement?
Yes.
Do you remember that you had more to that statement that was left off when he confronted you with it?
I'm sure there's more to this.
To complete your statement, you said, but in the whole context, I believe that those are signs of hypothermia and not caused. Do you remember that completion to your statement?
Objection, Your Honor.
Sustained. You can show a receipt.
Okay,
Objection, Your Honor.
can approach. Ask you to take a look at part of your grand jury testimony. Do you remember Attorney Alisi reading part of your answer back?
Objection, Your Honor.
So I'll strike that. Have the witness look at it and go from there.
You asked about your entire answer or just part of it?
Objection, Your Honor.
Sustained.
You can read the rest of the answer that you weren't given when it was read to you.
Objection, Your Honor.
So this is phrased as refreshing recollection, so follow it appropriately.
You now remember there was more to your answer?
Yes.
Could you share with us the rest of your answer?
Without reading
Objection,
it.
Your Honor.
Without reading it. Turn the paper over, please.
I can paste it on.
The
Yikes.
appropriate question, Mr. President.
Yeah,
Remember
Brennan
the
is
part that was
tanking
left
this.
Objection, Your Honor.
Sustained.
Does it refresh your memory to the rest of your statement to the grand jury?
I'm sorry, what was your question?
After looking at this, does it refresh your memory to the rest of your statement you made to the grand jury?
Yes.
And could you share the rest of your statement with the jury, please?
Objection, Your Honor.
The rest of the statement was that I have to take those findings in the context which was presented to me. So in the case of this particular case, those hemorrhages, in the context of a body found in the snow, I believe they were due to hypothermia.
Is your answer more complete in context?
Objection, Your Honor.
Sustained.
You were shown a photograph of
Yikes.
two individuals that were in the room at the time of autopsy. Do you remember that photograph?
Yes, I do.
And you were asked about certain names.
Correct.
You said that there would be a log identifying names.
It would be a log. Yes.
A log. Do you remember exactly who logged in to that autopsy?
No, I don't remember their names.
May I approach?
Show Mr. Lesson.
Part of the end of the report. It's in there. Take a look. You have it?
Your Honor, if we need sidebar to explain, we just need a moment to take a look.
I can move on and we'll come back to it, Your Honor.
Objection, Your Honor.
You mentioned that Mr. O'Keefe's body temperature was a little under 81 degrees when he was brought to the hospital.
Yes, that's what the hospital records stated.
And again, a normal body temperature is?
98 degrees.
So there was, is it fair to say there was over an 18-degree drop in his body temperature?
Correct.
You shared with us that you generally understood it was a blizzard and cold outside. Do you have any experience on how rapidly a body temperature will drop outside?
the body temperature.
Yes.
Oh, it's within the scope. Let's see if she's got the basis.
The rate that the body loses heat depends on a number of factors. Depends on conditions, weather conditions. It depends on the original temperature of the body, and the higher the gradient between the body temperature and the environmental temperature, the faster the drop will occur.
You were asked if there was any signs of frostbite. There was no type of freezer burns or anything on Mr. O'Keefe's body, was there?
Sustained.
Was there any type
Objection, Your
of
Honor.
burns on his body that would suggest that he was put in some type of machine or environment where there was cooling, mechanical cooling?
Sustained. Sustained. Move on, Mr. Brennan.
You were
He's
shown
getting
a
killed.
photograph
This is
of
the
chalk
worst redirect ever.
that had spots on them. Do you know where that photograph came from?
I do not.
Do you know who that was from, what person that was from?
No, I do not know the context of that picture.
Do you have any information on the circumstances which led to that condition?
I do not.
Do you have any information about what caused the condition that you saw on that chalk?
I have seen similar pictures in textbooks
This is
depicting
crazy.
gastric hemorrhages or Wisniewski spots.
You were asked about your role as a medical examiner, and there were a number of questions about your assessment from a legal perspective.
Yes.
You mentioned that you had information from a police report. How many police reports were you given?
There was a preliminary police report, I believe, the day of the autopsy, and communications with law enforcement in the days and weeks following.
May I approach?
Yes.
Objection, Your Honor.
Document, do you recognize that document?
Wow.
Yes.
What is it?
This is a police report on this particular case.
Is that a police report from your file?
Yes.
And that police report, is that the police report that you considered?
Amongst other information, yes.
How many lines is that police report?
11.
What's the date and time of that police report?
This was initiated on January 29th. It says at 1941.
I have this marked for identification, Your Honor.
Okay.
And in the, what's this, another document?
Let us mark it.
Oh, sorry, let me have that back.
Yeah.
Q for identification.
Thank you. May I approach, Your Honor?
Yes.
Second document, was that another document in your file?
Yes.
And is that another report that you considered?
Yes.
How many lines is that report?
5.
I'd move to have this marked for identification, please.
Okay.
Thank you.
Civic RR for identification.
May I approach again?
Yes.
I'm going to go back to the questions I asked you about logging in and refreshing your memory. I'm going to hand you the document. I'm not going to actually read it aloud. I'm just going to ask you to look at it. Does it refresh your memory on people who attended the autopsy?
Yes.
And who were they?
I believe one person was Mr. Keefe and the other one was Mr. Corner.
Are you part of the criminal investigation team?
No, I am not.
Did you go to the scene and evaluate any evidence?
No, I did not.
Did you do any of your own detective work or investigation in this case?
No, I did not.
So when you were asked questions about your role as the medical examiner in your medical evaluation of Mr. O'Keefe's body, you were also asked whether you considered any part of the legal aspect. Do you remember those questions?
Yes.
You were never, well, let me ask you. You submitted the death certificate on April 14th?
Correct.
I want to talk about some of the things that you may or may not have known about or considered at the time you wrote your death certificate or filed your death certificate. Were you informed or were you aware that before you filed your death certificate, there was information in the investigation that police spoke to a first responder by the name of Timothy Nuttall, who reported that the defendant
I'm going to allow it.
that the defendant said, I hit him, I hit him, I hit him. Were you aware of that
I became aware of it at some point.
during your 90-day window?
I believe so.
Were you
Why is-
aware that there was another first responder by the name of McLaughlin?
I'm sorry. What? Why are we asking the medical examiner about this? I don't understand this. Why? What? Why are we asking the medical examiner about something Karen Reed said? This makes no sense. This is desperation.
Are you part of the criminal investigation team?
No, I am not.
Did you go to the scene and evaluate any evidence?
No, I did not.
Did you do any of your own detective work or investigation in this case?
No, I did not.
So when you were asked questions about your role as the medical examiner in your
How was he
medical evaluation
able to ask
of
this?
Mr. O'Keefe's body, you were also asked whether you considered any part of the legal aspect. Do you remember those questions?
Yes.
You were never, well, let me ask you. You submitted the death certificate on April 14th.
Correct.
I want to talk about some of the things that you may or may not have known about or considered at the time you wrote your death certificate or filed your death certificate. Were you informed or were you aware that before you filed your death certificate, there was information in the investigation that police spoke to a first responder by the name of Timothy Nuttall, who reported that the defendant
Object. What is this question? Are you aware that Charlie told John that Sarah said that she went to the store? Bro. What are we doing?
I'm going to allow it.
that the defendant said,
And she
"I hit him,
allowed
I hit
it?
him, I hit him." Were you aware of that
I became aware of it at some point.
during your 90-day window?
Why?
I-
Why would the judge allow this question? Are you aware that a first responder told a police officer that Karen said that she hit him, she hit him, she hit him? Why are we asking a medical examiner this? Judge Beverly Canoni. This is some royal BS. How?
Believe so.
My
Were you
attorneys.
aware that
Hey.
there was another first responder?
I need some help from the attorneys on the channel. What in the world is this question? Are you aware that the first responder told a police officer that somebody else said, what?
There was information in the investigation.
I gotta hear
that
this
police
again.
spoke
This is
to a
crazy.
First responder by the name of Timothy Nuttall, who reported that the defendant
I'm going to allow it.
said, "I hit him, I hit him, I hit him." Were you aware of that
I became aware of it at some point.
during your
What?
90-day window?
I believe so.
Were you aware that there was another first responder by the name of McLaughlin who provided information that the defendant said, "I hit him, I hit him, I hit him, I hit him"?
What is this?
Yes.
What is this
Were you
question?
aware of statements made by the defendant, to Ms. McCabe, that she said, "May have I hit him? Did I hit him?"
Objection, may we approach, please, briefly?
Okay.
How is I need an attorney. Is Kel Bell in here? I need an attorney. I need I am so lost. How in the world is he allowed to ask the medical examiner about what a first responder saw or said, or What's she aware of? How is this relevant? It's called hearsay. Well, I mean, it's not really hearsay because it's fact. They're facts and evidence, right? But how is this relevant?
So,
I don't know.
jurors, I want to let you know that, like other evidence that was let in previously, this is not coming in for the truth of what's in the statements. It's coming in so that as it goes to Dr. Scorti-Bello's knowledge and state of mind at the time of her report.
What?
Thank you. At the time of your death certificate that you filed, were you informed that a Jennifer McCabe
This is
had
crazy.
reported
I had to take a
that
drink.
the defendant said, did I hit him or could I have hit him multiple times?
Objection, Your Honor.
I'm going to allow it.
I don't believe I knew about Miss McCabe.
Did you
Wow.
learn that Ms. McCabe reported later that the defendant, while speaking to first responders, reported that she had hit him? Did you know that?
That, yeah, I was aware of that information later on.
Were you aware of the investigation regarding alcohol consumption?
Yes,
Were you aware that the police or Massachusetts State Police spoke to other witnesses about their observations that night?
about their,
Their observations?
yes,
Were you aware of an interview by Trooper Buchanan with firefighter Daniel Whitley on February 7, 2022?
I need an attorney. I need help.
I don't remember.
I'm gonna call Joe.
Were you
I gotta call
aware
Joe Tacopina.
That Mr. Whitley told
Joe,
the
help
police
me.
that the defendant had expressed that she had gotten into an argument with the defendant that night?
That was part of the information I was given, yes.
Were you aware of a report from first responder Anthony Flamate about statements made by the defendant to him?
I don't recall that particular first responder, no.
Were you aware of statements provided by Kerry Roberts to the police that the defendant had called her, citing Kerry, John is dead,
Yeah, I was given that information,
and the questions of did I hit him? Were you aware of that?
yes.
Were you aware of information that troopers had an opportunity to go and speak to the defendant?
Yes,
Were you aware of the statements that she made to the troopers?
not in detail.
Why
Were you
are
aware
we
that when they
asking a
spoke to her
medical
on January
examiner about this?
She informed that she had a broken taillight on her vehicle but did not know how it happened?
Objection, Your Honor.
I'll allow that.
Yes, I was provided with that information.
Were you provided the information that she had never observed John enter the residence?
I believe that was part of the original information, yes.
Were you aware that she informed relative to the broken right taillight she didn't know how it happened?
Yes, I was.
Were you aware that members of the Massachusetts State Police obtained John O'Keefe's phone and did a forensic data analysis on it
I was not aware of that until much, much later.
after you filed your report?
Correct.
Were you aware of location data that was obtained from John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of healthcare data on John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of battery temperature data on Mr. O'Keefe's iPhone before you filed your death certificate?
No, I was not.
Were you aware of voice messages left on John O'Keefe's phone from the defendant before you filed your death certificate?
No, I was not.
Were you aware of text messages between the defendant and John O'Keefe before you filed your death certificate?
No.
Were you aware of statements from the defendant to various media outlets before you filed your death certificate?
No, I was not.
Did anybody ever come to you after you filed your death certificate and ask you to change it?
No,
Did anybody ever provide you any of this additional information you weren't aware of at the time, ask you to evaluate it, and then reconsider your finding?
no,
You were asked some questions about impact injuries. In your experience, are most pedestrian collisions where there's injuries to the lower legs either frontal or rear impacts?
Objection, Your Honor.
I'll allow that because I'll allow that.
Man,
most pedestrian fatalities that we see are with impact with the front of the vehicle.
When you gave the perspective that you looked for impact injuries, was that with consideration of your experience that most collisions are frontal impact injuries?
Most collisions involve frontal impact, yes.
How about cases where you had an opportunity to observe people who sustained injuries from being clipped? Not hit, but just being clipped. Is your opinion any different in your experience?
Objection, Your Honor.
Sustained in that form.
objection, Your Honor.
How about a side swipe injury? Is that different relative to your expectations to lower extremity injuries?
Objection, Your Honor.
Sustained.
A bruise on the knee, is that consistent with a side swipe impact?
Could be.
Did you do any type of biomechanical analysis of any alleged collision in this case?
No, I did not.
Were you asked to?
I'm not qualified to do that.
And so when you talk about injuries from a collision, are you in part speculating about what could happen to somebody?
Objection, Your Honor.
Sustained in that form.
Are you giving a direct opinion in this case about how the injuries were caused?
Objection, Your Honor.
Sustained.
You were asked questions about a nose laceration,
Yes,
and you offered that was not consistent with falling backwards on the head alone.
correct,
You were asked if that was consistent with a punch.
correct.
Objection, Your Honor.
That's not the testimony. That's your objection.
That is, Your Honor. There's no question.
Did you provide an opinion that it could be consistent with a punch?
I did provide that opinion.
Could it be consistent with broken glass?
It's possible.
Could it be consistent with sharp shards from broken plastic?
Possible.
Could it be consistent with first aid?
I'm sorry, what was
Could it
it?
be consistent with first aid treatment?
Anything is possible.
Do you have any firsthand knowledge of how the laceration on the nose happened?
I do not have firsthand knowledge.
Did you know at the time you filed your
Jeez.
death certificate that there was plastic pieces of taillight found near Mr. O'Keefe's body around 5:45 p.m. on January 29, 2022?
I do believe some of that information was communicated to us, yes.
Thank you.
All right, Mr. Lessie.
Thank you, Your Honor.
Some crazy questions.
Dr. Scorti-Bello, this Attorney Brennan just asked you questions about alcohol consumption. You had the opportunity to evaluate the medical records of Mr. O'Keefe, correct?
Correct.
And you had, in terms of the medical records, information with regard to the medications that Mr. O'Keefe had taken, is that correct?
I believe I reviewed those records at some point prior to issuing my report, yes.
Do you recall the list of medications that were in the medical records that Mr. O'Keefe was on?
I do not recall.
If I were to show you a document, might that refresh your recollection as to the list of medications?
Overruled.
Going
Gotta
to
let
allow
in.
it is in connection with alcohol, too, you said, right?
Correct, Your
Go right
Honor.
ahead.
I didn't realize John was on medication. Did y'all know that?
Yes.
Peter, her saying anything is possible is not helping the prosecution. That's reasonable doubt, dude. Come on, Peter. I know you hate Karen and you want to see her under the jail. But when it comes to this witness, this ain't it. If anything's possible, then we have reasonable doubt. Like, come on.
Dr.
That's called reasonable doubt, sir.
Dr. Scorti-Bello, may I stand by the witness?
Yes.
Thank you. Dr. Scorti-Bello, I am providing you with
Oh, man.
a document. Up at the top it says John O'Keefe, and I would like to draw your attention to medications. And to expedite it, I am going to focus on the fourth item on that list. Can you state what that medication is?
The fourth item is omeprazole.
Does that refresh your recollection as to one of the medications Mr. O'Keefe was on?
Yes,
And that medication is,
it's an antacid.
right, and so omeprazole is the trade name of omeprazole Pepsid?
I believe so.
And Pepsid is a proton pump inhibitor?
Correct.
And a proton pump inhibitor stops the proton pump in the stomach from releasing acid, correct?
Yes.
And we're going to come back to that in just a moment, but do you also recall testifying at the grand jury with regard to alcohol consumption and potential alcohol consumption of Mr. O'Keefe?
I do remember testifying, yes.
And do you recall what your testimony was with regard to alcohol consumption and small ulcers in the stomach potentially associated with alcohol consumption?
Alcohol consumption, I don't recall my exact words at grand jury, but alcohol consumption can lead to gastric ulcers.
And alcohol consumption can lead to gastric ulcers. And what medications can treat gastric ulcers?
Well, they don't treat them, they prevent them, but that would be a proton pump inhibitor such as omeprazole.
Right. So, isn't it correct, therefore, that the ulcers that are observed in the stomach of Mr. O'Keefe that we talked about, the gastric mucosa, could have come from ulceration due to alcohol consumption,
It's possible.
as opposed to hypothermia, correct?
Correct.
Attorney Brennan asked you questions moments ago, and actually several of them, of which included the words, did I hit him, could I hit him? Do you recall those questions?
I do.
And isn't it correct that you had that information before you issued your final findings in this matter in April of 2022?
Yes, I did.
So, even though you had all that information, you still were unable to conclude the manner of death of Mr. O'Keefe, correct?
Correct.
Thank you, Dr. Scorti-Bello.
All right, doctor, you are all set.
There it is. The doctor is all set.
Sidebar.
Oh, man. Y'all. Wow. The reasonable doubt is flying around this courtroom like crazy. I don't know what, I don't know how the prosecution is going to move forward. We'll have to see something major that definitively said Karen Reed was the one who did it, because I'm not seeing it here. And again, the burden of proof is on the, well, I want to say state, the Commonwealth, and we have not seen it. Uh-oh, they're giving up their badges, so it looks like the day might have been over here. Let me, oh, that's right, because we had something that happened after court was done. Hold on a second.
We are on schedule. So with that, I'm going to let you go a few minutes early, so please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be very careful with your social media. So we'll see you tomorrow morning.
The rest of the jury.
And real quick, shout out to Kara Hampton with the Tim bomb. Says it's Friday. I may have been late to the party, but I made it on purpose. You know what time it is. Let's get ready to start the weekend, starting with today. Let's make the whole weekend great on purpose. Shout out to Kara. I love that. Let's be great on purpose, y'all. I love that attitude, Kara. And I appreciate you bringing that to the community. We need more of it. Yeah, man, they need to.
All right,
I don't
so
know. I'm
Mr.
about to get
Leslie,
my
I'll hear you.
FKR t-shirt, y'all. I'm almost there.
I'll hear you, Mr. Leslie.
Thank you, Your Honor.
The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand.
Here we go. Hold on. Let's run this back. We're talking
hear you,
about
Mr. Lett.
witnesses real quick.
All right, so
we go.
Mr. Lessie, I'll hear you. I'll hear you, Mr. Lessie.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welter, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes, that
Okay.
my understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay?
So the Commonwealth has established in reports right up until, not established, they have stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162.2 that they have associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been
Oh, there's nothing that
assuming
happens here.
that information, and this is from best memory, but I believe it's slide 137 or so, where the statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period.
Who's Shannon Burgess?
I'm just going to get
I'm gonna find out here in a second.
So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states
Nothing gets
that
decided.
he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally, by seconds, determinative in some ways of various analyses. So we basically commissioned, if you will, ARCA to be looking at matters based upon
Oh, we got ARCA back in it.
Infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA, it's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffin's analysis. And Mr. Whiffin's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very,
okay, so we're gonna get it.
Almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation, remedy be that this is not allowed, and that the Commonwealth proceed with its the information of Aperture that has been extant before the May 8th date of the report. Thank you.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer your question, but with just the quick point that this is really much different than ARCA because two reasons. We are the defense, and ARCA is a rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you
Right.
have
So-
another
so
option.
It's
Just
not
from
what
the
I
end of the day
am,
yesterday,
am
Libby.
saying that I am proffering. I think the only remedy here is exclusion and a Rule 14 violation.
And you're not waiving that.
I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a
Right.
chance to talk to ARCA.
All right, so tomorrow morning, let me know that. All right,
In Your Honor, I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffin. I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffin based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense, in theory, is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's question.
all right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense is entitled, continues to work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. And if you recall in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they potentially called. Mr. DeSorga wrote a report, and in the report he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the text stream data, the black box data from the car, has an event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09. There is a variance between those times. We asked our expert to review their expert's report to see if he was accurate that the variance means that these times would never align. And that's what he did. He studied the data, he studied the ways, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned, from his opinion, is that Mr. DeSorbo was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event, of the ignition, on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moments when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text screen data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no
So he's saying they did their part.
Have this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief, or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
In my case in chief, because we now have this available data. As I said, this wasn't ambush, isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay. Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his 4 categories quickly. He said, he referenced Mr. DeSorbo, who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within the reciprocal discovery deadline.
Okay.
And he provided that report months ago.
Oh.
So if, as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago.
Okay.
The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different.
Here we go.
Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months.
Mm-hmm.
I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first
All
trial.
right. I thought Burgess was, no?
No one from Aperture was.
I knew
Your Honor.
Aperture was, and I thought he may have been something. The name just sounded.
Neither
familiar.
Burgess nor Welcher were
Okay.
part of the first trial, but they were retained. Aperture was retained, I believe, in October of 2024.
Okay.
And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay, so what I'd like to do, because I want to address the other issue and I don't want to keep people here too long, can you wrap it up, Mr. Alessi, or is that?
In 60 seconds.
Okay.
Thank you, Your Honor.
She loves telling them to wrap it up.
The last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard.
He's
So
not
if
surprised.
the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding, fetching reason to not allow it, because they're surprised to get it. And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay, thank you. The other issue about
He's very, very passionate. Yes, I agree.
calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCA materials. What's your argument on that?
I won't iterate the entire past. but
Clock
Your Honor
drift
has
is a bad name.
Discovery violations. Your Honor has found that
What?
I want to phrase this properly, the efforts of the defense were improper. And inevitably, we've now
He's upset about discovery again.
extraordinary amount of discovery.
Oh, boy.
The most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled the government's objection and has stated that it's going to allow the defense to proffer two expert witnesses in a very complicated field.
What's up, Tay?
In an issue that is the heart of this case. If you're going to allow them to testify, despite the fact that we have not had adequate time to review, to prepare, and to address it. The Commonwealth has the burden of proof.
Y'all just need to drop
The
this thing,
Commonwealth
man.
has an obligation to prove this case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Weckler. As you know, he was away. He did not get a report until maybe May 7th. He did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case for the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple four opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARCA witnesses. That's going to take time. You've heard from the ARCA witnesses themselves. With the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadlines.
It's just late discovery arguments,
They were
Slim
given
Life.
5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our experts.
So the judge is probably going to set a deadline.
Do his testing, provide opinions. None of that is going to happen anytime soon because he still has not finished reviewing all the materials. There's many, many gigabytes. He's in a difficult schedule. He is away tomorrow, Saturday. We will go to try to begin to prep at the end of the weekend. There is no way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what we would like to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARCA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing materials actively engaged in his own testing now. So by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders, and so that he can then address the jury on those specific new issues. I see no other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. We ask that he be able to continue his review, offer rebuttal opinions on anything that is new, and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No, because Dr. Welcher relies on Shannon Burgess's information material. It will make no sense. I thought about it. It makes no sense to the jury, his presentation, unless Shannon Burgess has an opportunity to provide the background information.
All right. Mr. Lessie, I'll hear you on this.
Thank you, Your Honor. I think and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARPA and the information of ARPA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARPA that have been in existence since February of 2024.
Yeah, let's focus on the
Jeez.
beyond. Let's focus on
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that.
So if we're focusing just on the quote new information bucket, Your Honor, it's very important to understand
Did they get the
that
report
what
late?
ARPA is doing is in response to the testing of Aperture. ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new
That's true.
information from ARCA. When
They talked about it. They said when AJ was up there, he said, Judge, as soon as we get the information from ARCA, we will hand it directly over. And she said, okay, what are we doing here?
Dr. Rentschler was on the stand. Dr. What you said,
It's
when
not
can
that
you get me
complicated.
the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. We
They can't force
proceeded
ARCA to give
along
them
with the
information.
trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address this matter as if the defense is making perpetual violations. There was a determination
Exactly.
made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCA have to come on, and then have Aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double re-rebuttal, surrebuttal to the defense. I believe, Your Honor, the final point is if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And, Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right, so I have a question for you, Mr. Leslie. Are you still thinking that if the defense puts on a defense, that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this, because obviously you have no burden, if ARCA is part of that defense, when in that week and a half time frame?
I can't wait to hear from ARCA.
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so I appreciate it. All right. Thank you.
There it is. All right, now we can fast forward. Shout out to y'all. Let me know what you think about that. I cannot wait until we get into the ARCA testimony. ARCA. Is it ARCA or ARCA? Let me know which one y'all think in the comments in the chat. We got a couple of super chats to get to, and then we are going to get into officially the court proceedings today. Y'all know we like to have a delay here. We're probably going to lose our delay by the lunch break, but it's worth it for sure. Shout out to Kara Hampton in the building, gifted 5 memberships. If you got a membership from Kara, make sure you say thank you, and make sure y'all check out the emojis, the member emojis you can use in the chat, and the member only content we have over there. Big shout out to Kara, and make sure y'all thank her. We got Peter Ortiz in here just chilling with the super sticker out there in St. Thomas. He said, thanks for being you. Thank you, Peter, for being you. Major supporter. It's ARCA. Is it ARCA? Is it ARCA or is it ARCA? Which one? ARCA? 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 All right, that's enough of this, man. Let me change the title of this, and we'll go ahead and get into J17. I believe we have an expert witness that is coming up to the stand. Here we go.
Good
You know we got to
morning
start
again,
the day
counsel.
with
Good
the
morning again,
BS.
Ms. Reed.
Y'all know the jury's been watching this channel.
So, I appreciate your patience.
ARCA.
I have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes.
You know that's not true.
Were you also able to follow my instructions and refrain
Thanks for being here,
from
honeybee.
any independent research or investigation into this case? Yes. Everyone said yes.
Oh my
and I
gosh,
affirmative
it's a
vote.
joke.
Did
Good
anyone happen to
gosh.
see, hear, or read anything about this case since we left yesterday? I have one other important instruction for you folks, and it's so important that each and every juror can hear the evidence or the testimony that's presented, can
True.
follow the testimony, and can understand
ARCA.
and evaluate the testimony of each witness and the exhibits. In order to do that, I just want to be very clear that it's important that people do not comment on the evidence or make any comments. Once you enter the room, it's probably a good idea to just listen. Don't talk. Don't make any facial expressions. No muttering under your breath. No audible noises, because people need to hear what's going on and to understand everything. So out of respect for your fellow jurors, I would ask that you be very careful to make sure you don't do that, and out of respect to the lawyers who worked so hard to get this case before. Okay? Thank you very much. With that, Mr. Brennan, your first witness, please.
Or if I could begin by offering a stipulation that's agreed to between the parties.
Okay, can we turn the AC down, please?
Yeah, we don't have a video. We don't have a transitional video. That's kind of disappointing. Dang. What's up with that?
Thank you. Yes.
Your Honor, if I may, I'd like to read a stipulation agreement between the Commonwealth and the defense.
Okay.
And the stipulation between the parties is as follows. Now comes the Commonwealth and Karen Reed, the defendant, in the above captioned matter. Both parties respectfully stipulate to the following. The 2 Massachusetts State Police troopers present at the autopsy conducted by the medical examiner, Dr. Scortibello, on January 31st, 2022, where Trooper Keefe and Trooper Watson, former Trooper Michael Proctor, was not present.
Thank you.
And
Thank you for that.
Yes, thank you.
with that, Your Honor, I'd like to introduce and play clip number 21.
Ah, here we go. I knew it.
Oh, turn the AC off. Hold on 1 second, please. I just want that. Can the jurors hear better with that on?
So John's laying there, his left and his right, and I approach John from the left. That's where
Okay.
the street is. And he had a piece of glass, like, perched on his nose, like, just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
Interesting.
So we need this marked.
We need it
Have
marked.
the item.
Exhibit 169.
Mr. Lally, your next one.
Your Honor, the Commonwealth calls Andre Porto to the stand.
Is it Andre Porter? Let's say his name's Porter. Let's see who this fine gentleman is.
Do you solemnly swear the evidence given to the court and jury in the case now and hearing should be the truth, the whole truth, and nothing but the truth? So help you God? I do.
Morning. Hey, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
Yeah, my name is Andre Porto, last name spelled Porto.
And what do you do for
Oh,
work, sir?
Porter.
I'm a
Porto.
forensic scientist too in the DNA unit at the Massachusetts State Police Crime Lab.
And where did you go to school?
I received my undergraduate Bachelor of Science in Microbiology from the University of Massachusetts in Amherst, and then I received a Master of Science in Biomedical Forensic Sciences at the Boston University School of Medicine.
Now, following your education, where did you go to work?
I started at the Massachusetts State Police Crime Lab in the DNA unit.
Dr. Porter.
And how long
Porter.
have you worked at the state lab?
Oh, yeah, sorry.
How long have you worked at the state lab, sir?
Since September 2019.
Now, when you joined the lab, what was your position and title that you were initially hired for?
I was hired as a Forensic Scientist 1.
Now, can you please explain to the jury your duties and responsibilities as a forensic scientist 1?
Sure. So a forensic scientist 1 is a trainee position where we're hired and we undergo an extensive training program where we do undergo the analysis process in training casework samples, where we learn how to do the lab work and analyze profiles. And at the end of this training, I took a competency test to make sure that I was able to accurately conduct the DNA analysis process. And once I passed that, I was then put on to do casework. And a year after completing both my competency tests and a year after my hire date, I was then promoted to a forensic scientist 2.
And so you're currently a forensic scientist 2, is that correct?
Correct.
And what is the difference between a forensic scientist 1 and a forensic scientist 2?
So a forensic scientist 2 is just the automatic promotion that you get after a year of hire and passing the initial competency test. And we're able to do the DNA process in casework samples.
Now, sir, what type of analysis do you currently do at the Massachusetts State Police Crime Laboratory?
I can do the DNA analysis process in casework and known samples. That includes the lab work as well as analyzing the DNA profiles that are generated from the work.
Now, first, just in general terms, but specifically with reference to DNA analysis, can you explain to the jury how is that analysis performed?
Sure. So there's 4 steps in the analysis process. The first step is extraction, where we apply heat and chemicals to the samples to break open the cells and release that DNA to be available for use. Step 2 is called quantitation, where we take a small sample of that extract the DNA to estimate, and we use chemicals and run it through an instrument to estimate how much DNA we extracted. And then we proceed to step 3, which is called amplification. And that's basically, think of it as a molecular photocopier, where we target specific areas of the DNA to make millions of copies of it. And then we run it through, go to detection, where we run it through an instrument, and we generate the DNA profile as an electronic file on a computer.
Now, is the state lab where you work accredited?
Yes, it is.
And by whom?
We are accredited by an organization called ANAB, which stands for ANSI, National Accreditation Board, and ANSI stands for American National Standards Institute.
I need you to slow down, please.
Sorry.
Please.
Sorry.
He's just excited to be there, Judge.
Now, Mr. Porto, are there steps taken in your lab during that process that you were just explaining to prevent against contamination?
Yes, there are.
And can you explain what those are?
Sure. So there are various steps. One step to prevent contamination between analysts would be to bleach and wipe down the workstations before use and after. Another way to prevent DNA transfer from analysts to the samples is to wear personal protective equipment, such as lab coats, gloves, masks, hairnets, and beard guards.
PPE,
and a way
as
to
we
prevent
call it.
transfer from sample to sample would be to frequently change gloves, as well as only have one sample open at a time.
Now, with your work at the lab, is there a review process that your work undergoes?
Yes, there is.
And can you describe that process to the jury?
Sure. So once I complete my work, the file undergoes 2 types of reviews. The first is a technical review, where another qualified analyst will take the file and they'll do their own independent assessment and make sure that they come up with the conclusions and that they agree with the conclusions that I reached. And they'll also make sure that all the protocols were followed and every decision is scientifically sound. Once that review is completed, it undergoes an administrative review, where another qualified analyst will then look through the file and they look for clerical errors, such as typos or missing page numbers or missing case numbers. Once those 2 reviews are completed, the results can then be reported out.
Now, as a part of that accreditation process that you were speaking about a few moments ago, do you undergo anything called proficiency testing?
Yes, I do.
Yep.
And can you explain to the jury what that proficiency testing process consists of?
Yeah, so a proficiency test is a test that's administered twice a year by an external vendor, and the results of this test are not known to the analyst at the time. And we basically treat it like it's a real case, where it undergoes the analysis process as if it were a real case. And this test is used to show that the analyst is demonstrates ongoing competency in the DNA analysis process. And successful completion of the test is required to maintain qualification as an analyst.
And what areas do you specifically undergo proficiency testing in?
DNA analysis.
And have you successfully completed each of those proficiency tests that you've taken?
Yes.
Now, Mr. Porto, could you explain to the jury what exactly is DNA?
Yeah, so DNA stands for deoxyribonucleic acid, and it's
no.
basically the building block that makes us who we are. We each have 2 copies of our DNA, one that we inherit from mom
We
and
know
one that
what
we inherit from
DNA
dad.
is, doctor.
And this combination makes
he
sure
a doctor?
that, barring with the exception of identical twins, we all have different DNA.
And is DNA the same in every cell of a person's body?
Yes. So what that means is, if I were to take a blood sample and a saliva sample from the same person, the same DNA profile will be generated.
Now, you spoke a bit earlier about the different steps included in the DNA testing. If you could, just a little bit slower, go through each of those 4 steps again for the jury.
Sure. So like I said, it's a 4-step process. So extraction, quantitation, amplification, and detection. So extraction, we use chemicals and heat to burst open the cells to make that DNA available for use. Quantitation, step 2, we take a small sample of that extracted DNA. We use a different set of chemicals and an instrument to estimate how much DNA is available for use. Amplification is the 3rd step, which I mentioned is the basically molecular photocopier, where it makes millions of copies of specific areas of the DNA. And then the 4th and last step is detection, where we run those amplified copies through an instrument, and we generate the DNA profile as an electronic file on the computer.
Now, Mr. Porto, what is STR?
So STR stands for short tandem repeats,
Oh my gosh.
and they're the locations that we're making the millions of copies of.
Now, in your work at the lab, do you have something that's referred to as a known item?
Yes.
And can you explain to the jury what a known item is?
Sure. So a known item is an item that's taken directly from a person to be used as a reference sample, so we know what the source of that profile is.
And conversely, what is a questioned item?
A questioned item is an item that's taken, let's say, from a crime scene where we don't know what the source is.
Now, do you also have terminology within your lab as far as a parent versus a child item?
Yes, we do.
And can you explain how those labels are and how they reference to what you do in your work?
Sure. So a parent item is, for example, the original item, and the child is a sample of that item. So, for example, this box of tissues would be the parent item, and if you were to swab the outside, the swab would be the child item. So the box of tissues would receive, let's say, an item of 1-1. The swabbing of the outside would receive an item of 1-1.1.
Now, what are positive and negative controls?
Yeah, so a positive control is a control that has it's a known sample with a known DNA profile that we use in every step of the DNA analysis process to make sure that each step and instrument worked as expected and properly. And then a negative control is a sample that has no DNA in it. It only receives the chemicals that we use, and that's to ensure that the chemicals that we're using don't have any DNA inherent to them.
Now, when you as an analyst or a forensic scientist, too, are assigned work within the DNA unit, where do you retrieve that evidence from?
Yeah, so I retrieve it from a locked cold room that's only accessible via keycard.
Now, why are items kept in
Interesting
cold
stuff.
storage?
Yeah, the cold storage helps preserve the DNA for long-term storage.
And as far as the heat versus the cold, why is it that it's specifically kept, or why does the coldness of the storage room help preserve the item?
The cold can help prevent, let's say, growth of bacteria and mold that can degrade DNA.
And what does heat do, conversely, in reference to an item of forensic value?
Heat can help degrade DNA, and also promotes bacterial and mold growth that can further degrade that DNA.
Now, when you receive an item from the cold storage, how is that item typically packaged when you retrieve it from there?
Sure. So the item comes in these plastic, clear, transparent plastic sealed containers that has a label with a case number on it. And inside of that, each sample is within like a small plastic tube that has a label with a case number and item number.
Now, at some point, were you assigned to perform some work on a lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes, I did.
And what type of work in general terms were you assigned to do in this case?
I was assigned to do the DNA analysis process.
And that was on several items, is that correct?
Correct.
And could you explain to the jury the sort of the process that you used to analyze evidence in this case?
Sure. So the case underwent the 4 steps that I explained before. So extraction, quantitation, amplification, and detection.
And there was a known standard that was done in this case, specifically in item number 8-1.1.1, is that correct?
Correct.
And did another analyst test and report the results from the known blood standard from that item 8-1.1.1?
Correct.
And how is that done?
Yeah, so that undergoes the same process that I explained. It'll go through the 4 steps: extraction, quantitation, amplification, detection. And then the analysts that did the interpretation and reported that out, the known standard out, they went through the profile to make sure that it's from one person or single source. And once that went through the review process that I explained, so technical and administrative review, and once that was all completed, the standard was available to be used for comparisons.
And to whom was that known standard identified as belonging to?
John O'Keefe.
Now, you used the word in there as far as a single source. Can you explain to the jury what your understanding of that term is based on your training and experience?
Sure. So a single source is just a DNA profile that has one contributor to it. So only one person contributed DNA to that profile.
What exactly is a DNA profile?
Yeah, so a DNA profile is basically the combination of all of the locations that we amplified during the 3rd step of the process. And it's basically, you can think of it as like a chart, like an EKG, where it has peaks and valleys, and each peak has a specific number, and the DNA profile is just a combination of all those numbers put together.
Now, can you explain to the jury in general terms, to start with, the process of comparison between a known standard and a questioned or unknown standard?
Sure. So first, I did the analysis on the question items. I did the 4 steps. I analyzed the profiles that were generated. I then interpreted and make sure that I could determine the number of contributors. And once that was completed, I then used the standard that was available and compared them to all the profiles that were suitable for comparison.
Now, sir, starting with item 3-1.1, what was that a sample from?
That was a sample from taillight passenger.
And from a specific vehicle, is that correct?
Correct.
And what, if any, information were you given as to that vehicle that the swab from the taillight was from?
Do you mean like the license plate?
Yes.
Could I refer to my notes?
Yes.
Thank you.
Your Honor, with the court's permission, this is a little detailed as far as the testimony goes.
I don't have
maybe.
a problem. Does the defense object?
I do not object.
Okay,
Your Honor.
thank you.
Thank you, Your Honor.
So the license plate was 3G6684. Right, I'm sorry, 3GC684.
Now, with reference to the swab from the taillight, were you able to generate a DNA profile from that item?
I was.
And from your comparative analysis from that question item to that of the known standard of John O'Keefe, what did you conclude?
So the sample, the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least, I'm so sorry. I'll just restart. So the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least 510 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, what does that mean?
So an inclusion is basically when I look at the question DNA profile that was generated, and I compare it to the known DNA profile. And if the characteristics of the known profile are consistent with the characteristics observed in the question DNA profile, that's an inclusion.
Now, as far as that number, 510 non-alien, how many zeros in that number?
So a non-alien is a 1 followed by 30 zeros.
Now, that profile, in addition to Mr. O'Keefe's profile, also had 2 unknown contributors, correct?
Correct.
Now, was that item also submitted to an outside vendor named Bodie Technologies for further analysis?
Correct.
And with reference to your comparative analysis from the profile from this item to Mr. O'Keefe profile, if you could again just expound upon what does inclusion mean?
Yes, so an inclusion, I compared the known standard that I had available for use from John O'Keefe to the DNA profile generated from the taillight. And the DNA profile was, if that was consistent with the DNA profile that I observed in the questioned item, and that's what an inclusion means.
Now, regarding item 3-6, what is the description of that item?
Yeah, so 3-6 is a root end of hair from exterior passenger side rear panel.
And is that the same vehicle as far as the taillight sample?
Correct.
Now, with respect to hair in general, there's a root end and a shaft end, correct?
Correct.
And what limitations does your lab have with regard to DNA testing of hair?
So when we test hair, we're actually, the root end of the hair, we're looking at any potential skin cells that might be attached to the root end. So that's where the DNA that we're looking for is coming from. And if there's not too many, yeah.
Now, are you familiar with the term based on your training experience known as autosomal DNA?
Yes.
And can you describe for the jury what your understanding of that term is?
Yeah, so autosomal DNA is DNA that's located in the nucleus of the cell, and that's the DNA that we inherit from both mom and dad.
Now, are you also familiar, based on your training experience, with a term known as mitochondrial DNA?
Yes.
And can you please explain to the jury what your understanding of the term mitochondrial DNA is?
Yeah, so mitochondrial DNA is DNA that's found in the mitochondria of a cell, and we inherit that from the mother.
You don't
It
say.
may be somewhat evident, but could you please explain to the jury sort of the difference between autosomal DNA on the one hand and mitochondrial DNA on the other?
Yeah, so like I said, the autosomal DNA is the one that we have 2 copies of, where we inherit one from mom and one from dad. And then the mitochondrial DNA is a circular DNA that we just inherit from mom.
Now, is the Massachusetts State Police Crime Lab equipped to perform mitochondrial DNA testing?
No, we're not.
Now, was the DNA extract from the hair also sent to that external vendor, Bodie Technologies, in Lorton, Virginia?
I'm not sure if the extract was sent, but I know that the shaft of the hair was sent to Bodie.
Now, what testing did you perform on the hair?
I did the regular DNA analysis process on the root end of the hair.
And that was done prior to it being shipped to that external vendor, is that correct?
Correct.
And what conclusions were you able to draw from the testing that you did on the hair?
Yeah, so there was no human DNA detected, and STR analysis was not performed.
Now, what does that mean, sir?
Yeah, so it means that there were I didn't detect any human DNA, so there might be DNA on there, but it was below what our instrumentation could detect.
Now, turning your attention to item 3-2.1.1, what is the description related to that item, sir?
It's a sample from the exterior of broken drinking glass.
And is there any further indication as far as the broken drinking glass, as far as where it was recovered?
Oh, yeah, 34 Fairview Road.
And were you able to generate a DNA profile from this item, the drinking glass?
Yes, I was.
And from your comparative analysis from this question item to that of the known standard of John O'Keefe, what did you conclude?
Yeah, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 530 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This supports an inclusion.
Right, and so what we have ultimately is that there is no evidence, none.
This is the last time I'll ask you this, but just if you could reiterate to the jury, what does an inclusion mean?
Yep, so an inclusion is when
I'm just gonna let
I
him keep
compared the
going.
known standard
I'm
to
gonna let
the
him cook.
question item, and if the profile in the known standard is consistent with the profile in the question profile, that's an inclusion.
And that number again, as far as 530 non-alien, how many zeros again in that number?
That's a 1 followed by 30 zeros.
Now, sir, if I could turn your attention to another item, 7-1.2.1, what is the description related to that item?
Sample from stain A on upper right leg of jeans.
And is there any further indication as to whom those genes belong to?
John O'Keefe.
Now, were you also able to generate a DNA profile from this item, the stain A on the upper right leg of Mr. O'Keefe's genes?
Yes, I was.
And from your comparative analysis from the question item to that of the known standard of John O'Keefe, what did you conclude with reference to that item?
The DNA profile was interpreted as a mixture of 3 contributors, including male DNA. Contributor 1 is suitable for comparison, and due to limited information, contributors 2 and 3 are not suitable for comparison. The DNA profile from this item is at least 570 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Thank you, sir. Now, turning your attention to item 7-1.3.1, what is the description related to that item?
Sample from stain B on upper right leg of jeans.
And same genes as the previous item?
Yes.
Now, were you able to generate a DNA profile from this item, stain B, on the upper right leg of the genes of Mr. O'Keefe?
Yes, I was.
And from your comparative analysis from this questioned item to that of the known standard of John O'Keefe, what did you conclude?
Yep, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 660 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Okay, meaning what?
Now, sir, with reference to item 7-1.4.1, and again, these items with the dash and the point, is that what you were referring to earlier as the parent-child relationship between items?
Yes.
And what is the description for 7-1.4.1?
Sample from stain C on upper right leg of jeans.
Now, were you able to generate a DNA profile from this item from stain C on the upper right leg of Mr. O'Keefe's genes?
Yes, I was.
And from your comparative analysis of this question item stain C to that of the known standard of John O'Keefe, what did you conclude?
The DNA profile is a mixture of at least 2 contributors, including male DNA. Contributor 1 is suitable for comparison, Due to limited information, contributor 2 is not suitable for comparison. The DNA profile was interpreted as a mixture of 2 contributors. The DNA profile from this item is at least 830 non-million times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, with reference to item 7-1.5.1, what was the description of that?
Sample from stain D on upper right leg of jeans.
Now, were you able to generate a DNA profile from this item from stain D on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from this item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 670 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Great.
Now, sir, did you also do some testing on an item 7-1.6.1?
Yes, I did.
And what was the description associated with that item?
Sample from stain E on upper right leg of jeans.
And were you able to generate a DNA profile from that item, stain E, on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from that questioned item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 1.0 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides a support for an inclusion.
I used a different number there as far as a decillion. How many zeros is a decillion?
Yeah, a decillion is a 1 followed by 33 zeros.
Now, with each of those items that you just testified about as far as the genes, the question items from the stains on Mr. O'Keefe's jeans, those were each located on the right leg, correct?
Correct.
Now, did you also perform some analysis on item 7-1.7.1?
I did.
And what is the description associated with that item number?
Sample from unstained areas of the exterior of jeans.
Sounds
Now,
like
were you able to generate a DNA profile from that item from the unstained areas of the exterior of Mr. O'Keefe's jeans?
I was.
And from your comparative analysis from this questioned item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 4 contributors, including male DNA. The DNA profile from this item is at least 53 septillion times more likely if it originated from John O'Keefe and 3 unknown individuals than if it originated from 4 unknown, unrelated individuals. This provides support for an inclusion.
And again, sir, with that number, as far as 53 septillion times more likely, how many zeros in a septillion?
A septillion is a 1 followed by 24 zeros.
Now, sir, if I could turn your attention to what's listed as number 12 in your report, but item 7-18.4.1. Did you do some testing on that item as well?
Yes.
And what was the description associated with that?
Sample from stain C on top front of Gray's long sleeve shirt.
And the gray long sleeve shirt, is that attributed as belonging to a specific person?
Yes, John O'Keefe.
And were you able to generate a DNA profile from that item, specifically sample from stain C on the top front of the gray long sleeve shirt of Mr. O'Keefe?
I was.
And from your comparative analysis from that questioned item from the shirt to the known standard of John O'Keefe, what did you conclude?
So the male DNA profile was interpreted as originated from a single contributor.
Okay.
The DNA profile from this item
Not
is at least
surprising.
58 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
And again, sir,
So
that
is John's
number as
DNA.
far as 58 octillion times more likely, how many zeros in an octillion?
So an octillion is a 1 followed by 27 zeros.
Now, sir, if I could take you down to listed as 15 in your report, but did you do some testing on item 7-18.14.1?
I did.
And what was the description associated with that item?
So sample from stain L on back bottom right of gray long sleeve shirt.
And were you able to generate a DNA profile from that item?
I was.
And from your comparative analysis with reference to that item, the sample from stain L on the back bottom right of the gray long sleeve shirt, in comparison to the DNA profile from the known standard of John O'Keefe, what did you conclude?
So the DNA profile was interpreted as a mixture of 2 contributors, including male DNA. The DNA profile from this item is at least 1.0 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, did you also perform some analysis on an item numbered 7-18.17.1?
I did.
And what was the description associated with that item, sir?
Sample from unstained areas of exterior of gray long sleeve shirt.
And similarly, were you able to generate a DNA profile from that item, the sample from the unstained areas of the exterior of the gray long sleeve shirt of Mr. O'Keefe?
I was.
And from your comparative analysis from that question item to that of the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 960 non-alien times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Thank you, sir. I'm going to group a couple, 4 separate items from your report, starting with what's listed in your report as number 9 is item 7-3.1, correct?
Correct.
And what is the description associated with that item, sir?
Sample from stain D on right instep of sneaker.
And 11 from your report, you also did some analysis on item 7-18.3.1, is that correct?
Correct.
And what was the description associated with that?
Sample from stain B on top front of gray long sleeve shirt.
And item 7-18.7.1, do you see that as well?
Yes.
And what was the description associated with that item?
Sample from stain F on top front of gray long sleeve shirt.
And lastly, in this group, item 7-18.8.1, what was the description associated with that?
Sample from stain G on back left sleeve of gray long sleeve shirt.
And with respect to each of those last 4 samples from those items, were you able to generate a DNA profile with respect to each of those 4?
Profiles were generated from them.
And what did you conclude based on the generation of those profiles with those 4 items?
Yeah, so the profiles that were generated were not suitable for comparison.
And if you could explain briefly to the jury, when you say not suitable for comparison, what do you mean by that?
Yeah, so for 7-3.1, it was a mixture of at least 5 contributors. And at the DNA unit, we validated, basically we tested and make sure that our protocols were we can only interpret mixtures of up to 4 contributors. So I determined that there were 5 contributors, so that makes it too complex for us to do comparisons to it. So it's not suitable for comparison for that reason. And the other 3 items, due to the quality of the profile, they were not suitable for comparison. And basically what that means is that there were such low amounts of DNA that was in the sample that there was a lack of information from the profiles themselves, so they weren't really suitable for comparisons.
And just to be clear, the item that you're referring to with the 5 possible contributors, that's a shoot, correct?
Correct.
Now, if I could turn your attention in your report to what you have listed as number 10, there are a number of different items listed there, correct?
Correct.
And starting with item 7-17.2.1, what is the description associated with that?
Sample from stain A on top front left of orange t-shirt.
And 7-17.3, what is the description associated with that?
Sample from stain B on top of front left of orange t-shirt.
And item 7-17.4.1, what is the description associated with that?
Sample from stain C on top front left of orange t-shirt.
And item 7-17.5.1, what is the description associated with that item number?
Sample from stain D on front bottom right of orange t-shirt.
And item 7-17.6.1, what is the description associated with that?
Sample from stain E on back left shoulder of orange t-shirt.
And so each of those respectively were samples taken from stains on the orange t-shirt of Mr. O'Keefe, correct?
Correct.
Now turning your attention to item 7-18.2.1, what is the description associated with that?
Sample from stain A on right sleeve of gray long sleeve shirt.
And item 7-18.5.1, what is the description associated with that?
Sample from stain D on center front of gray long sleeve shirt.
And item 7-18.6.1, what is the description associated with that?
Sample from stain E on center front of gray long sleeve shirt.
And item 7-18.9.1, did you generate a profile from that item as well?
Yes.
And what is the description associated with that?
Sample from stain H1 on back left of gray long sleeve shirt.
And item 7-18.10.1, what is the description associated with that?
Sample from stain H2 on back left of gray long sleeve shirt.
And item 7-18.11.1, what is the description associated with that?
Sample from stain I on back right shoulder of gray long sleeve shirt.
And item 7-18.12.1, what is the description associated with that?
Sample from stain J on back bottom right of gray long sleeve shirt.
And lastly, with this group search, item 7-18.13.1, what is the description associated with that?
Sample from stain K on back bottom right of gray long sleeve shirt.
And so each of those items beginning with 7-18 were associated with various stains taken from various areas on the gray long sleeve shirt of Mr. O'Keefe, correct?
Correct.
And with respect to each of those areas of the orange T-shirt and the gray long sleeve shirt, were you able to generate a DNA profile from those items?
I was.
And from your comparative analysis of each of the DNA profiles from those items to the known standard of John O'Keefe, what did you conclude?
So the male DNA profile was interpreted as originating from a single contributor. The DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
Now, again, if you could just remind the jury, when you say single source contributor, what does that mean?
Yeah, so a single source profile is a profile that has one contributor to it. So like one person contributed DNA to that profile.
And with respect to the number as far as 490 octillion times more likely, how many zeros are in that number?
So an octillion is a 1 followed by 27 zeros.
Good Lord.
Now, lastly, sir, did you perform any analysis with reference to items numbered 8-2 and 8-3?
I did.
And what were the descriptions, respectively, for items 8-2 and 8-3?
So item 8-2 was right hand fingernail clippings from John O'Keefe, and item 8-3 were left hand fingernail clippings from John O'Keefe.
So fingernail clippings from both the right and left hand of Mr. O'Keefe.
Correct.
And were you able to generate a DNA profile from those item numbers, the right and left hand fingernail clippings of Mr. O'Keefe?
I was.
And based on, from your comparative analysis of the DNA profile from the right and left hand fingernail clippings, both of Mr. O'Keefe, taken in conjunction with the known standard of John O'Keefe, what did you conclude?
Yeah, so the male DNA profile was interpreted as originated from a single contributor, and the DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
So with respect to each the right
Lord.
and left hand fingernail clippings of Mr. O'Keefe, both of those were identified by you or your analysis as a single source contributor, correct?
Correct.
And they were each 490 octillion times more likely to have originated from John O'Keefe than from an unknown, unrelated individual. Is that correct?
Correct.
Thank you. Thank you, sir. I have nothing further on.
May I, Your Honor?
Yes.
All right, here we go. Is that Yannetti that I heard with the may I, Your Honor? It sure is. Let's get into the DNA. Because, boy, this
Good morning,
is
sir.
Good morning.
tough.
Mr. Porto, I would like to start by asking you about item 3-1.1, which you've identified as a sample from the passenger side taillight of the vehicle. Can you orient yourself in your report to that item?
Yes.
And that, of course, was the passenger side taillight that was attached to the vehicle, correct?
Correct.
You were never asked to do any DNA comparison on any pieces of taillight connected with this case, correct?
Let me check my other report. For taillight, there was another item that was item 3-3.1, which is sample from apparent glass on rear bumper, if that's what you're referencing.
Okay, so if I suggested to you that the taillight was plastic, that glass wouldn't have been the taillight, correct?
Correct.
I don't have, that's beyond my scope of testing.
Gotcha. Okay. With regard to the passenger side taillight, you found that there were 3 contributors of DNA to that taillight attached to the vehicle, correct?
Correct.
One of those contributors appeared to be John O'Keefe. Is that fair to say?
He was included into
right.
the profile.
With regard to the other 2 contributors, who were they?
They could be anybody.
Were you ever asked to compare DNA samples from either Canton Police Detective Kevin Albert or Canton Police Chief Kenneth Berkowitz to the DNA profile that you analyzed from that passenger side taillight?
I was not.
Interesting.
Now, with regard to the broken drinking glass, which is item 3-2.1.1, do you see that in your report?
I do.
With regard to that, you came up with a DNA profile that also had 3 contributors, correct?
Correct.
One of those contributors appeared to be John O'Keefe, correct?
He was included, correct.
Who were the other 2 contributors?
I don't know. They could be anybody.
Were you ever asked,
Well, that's
with
not
regard
conclusive,
to that
is
broken
it?
drinking glass, to compare the DNA profile that you analyzed with the DNA of either Boston Police Sergeant Brian Albert or ATF agent Brian Higgins?
I was not.
Why would you object to that?
Now, with regard to 7.1.2.1, or maybe it's 7-1.2.1, that's the stain A from the upper right leg of the jeans?
Correct.
All right. And you were aware, you were told that those were the jeans that John O'Keefe was wearing on the morning in question when he was found?
Based on the sample description, that's what it seems.
All right. And it turned out that his DNA was on his own jeans, correct?
He was included in the profile
All
from
right.
that
And
item.
that was unsurprising to you, correct? And with regard to that item, you found that there were 3 contributors of DNA, correct?
Correct.
With John O'Keefe being one of them.
He was included in the profile, yes.
And who were the other 2?
I don't know. They could be anybody.
Let's move on to stain B, also from the upper right leg of the jeans. That is 7-1.3.1. You see that in your report?
I do.
When you found a DNA profile, how many contributors of DNA were there?
3 contributors.
All right. And again, this was John O'Keefe's
So
jeans,
there's 3
correct?
different sets.
Based on the description, yes.
So he was one of the
DNA.
3 contributors.
He was included in the profile, yeah.
Who were the other 2?
I don't know. They could be anybody.
Moving on to stain C from the upper right leg of the jeans.
More reasonable doubt, guys.
7-1.4.1. You see that in your report?
I do.
With regard to the DNA profile that you analyzed there, how many contributors of DNA were there to that profile?
At least 2, and it was interpreted as 2 contributors.
And again, this is the same pair of jeans that he was found in, correct?
Based on the description, yes.
And you said at least 2 contributors. It actually could have been more than 2.
Based on our protocols, I had to call it 2, and we determined it as 2, but it could be more than 2, yes.
Okay. Well, let's pay attention to the one that was not John O'Keefe, at least that one. Who contributed that DNA to his pants?
I don't know. It could be anybody.
Moving on to stain D, which is 7-1.5.1.
Could it have been the dog? They don't know
If I
who
can just put my
the other
glasses
DNA
on
belonged to.
Make sure I've read my own writing correctly. Actually, is it 7-15-1? Did I get that wrong the first time?
D?
I'm sorry?
Do you mean
stain
stain
D?
D?
Stain D.
Stain D is 7-1.5.1.
Oh, I had it right the first time. Okay.
Right.
With regard to that stain, you also got a DNA profile, and how many contributors were there to that DNA profile?
I interpret it as 3 contributors.
And one of, and
I
again,
don't
this is John
understand these
O'Keefe's genes,
witnesses
correct?
from the prosecution.
He was one of the contributors to his own genes, correct?
He was included in the profile.
And
correct.
with regard to that stain on the upper right leg of his genes, who contributed the DNA to the, who were the other 2 contributors of DNA to that stain?
I don't know. They could be anybody.
And then finally, with regard to that upper right leg of the genes, there was also a stain
gosh.
E, correct?
Correct.
How many contributors did you find to that DNA profile?
2 contributors.
One of which was John O'Keefe to his own genes, correct?
He was included, yes.
And who was the other contributor to that stain on the genes?
They
It
don't
could
know.
be anybody. I don't know.
And by the way, just for the record, that was 7.1.6.1?
7-1.61.
7-1.6.1. Thank you, sir. Okay, now, with
I don't get
regard
where
to
the
the
Commonwealth is
unstained
going with
area
this.
of the exterior of the genes, do you see item 7-1.7.1?
Yes.
You found a DNA profile with regard to that unstained area as well, correct?
Correct.
How many contributors of DNA were there
It's a
to
lot
that
of DNA.
unstained area of the genes?
I interpreted it as 4 contributors.
And John O'Keefe was one of those, correct?
He was included in the profile.
His own genes.
Based on the description, yes.
Who were the other 3 contributors to that DNA profile?
I don't know. It could be anybody.
And before we move on to the sneaker, I just wanted to ask you a question about the passenger side taillight that I neglected to ask you. That was the one where there were 3 contributors, correct? And again, I'm going back to 3-1.1.
Correct.
Sorry to skip around, sir. I'm not trying to make this
It's all
any
right.
more confusing than it is. With regard to the
DNA
passenger
expert.
side taillight and that DNA profile, are you able to determine when that DNA was deposited on the passenger side taillight that was attached to the vehicle?
No, I'm not.
Are you able to testify with any certainty that it was deposited there, say, on January 28th or 29th of 2022?
No, I can't.
So, consistent with your analysis of it, are you able to say whether it occurred prior to January 28th of 2022?
No, I can't.
Were you aware that that vehicle was John O'Keefe's girlfriend's vehicle?
I was not.
Were you provided any information about just how often he had been in and around that vehicle prior to January 28th of 2022? So moving on to 7-3.1, which was the right instep of the sneaker, correct? You see that in your report?
Yep.
With regard to that particular stain, you noted how many contributors of DNA?
Yeah, it was interpreted as at least 5 contributors.
And when you have interpreted it as at least 5 contributors, what does that do to your ability to find out who contributed that DNA?
So based on our protocols, we're not able to do any comparisons to any mixtures that are 5 or more contributors, so it's not suitable for comparisons.
Okay, which means that with regard to the sneaker at least, you couldn't even say whether John O'Keefe's DNA was on it, correct?
Correct.
And with regard to all 5, do you have any idea who contributed the DNA to that sneaker?
No, I don't.
Now, moving on to, I just have a couple more for you, sir. Moving on to what is labeled as stain L, which is 7-18.14.1, I believe. Do you see that in your report?
It's a lot of DNA.
And that was a stain on the back bottom of his long sleeve shirt, correct?
Correct.
And were you told that the long sleeve shirt was his outer clothing when he was found?
I don't believe so.
How many contributors to that stain on
That's
the back
true,
bottom
Curious
of his
Coco.
long sleeve shirt did you find in that DNA profile?
I interpret it as 2 contributors.
And did you make any match with regard to either of those contributors or both?
I did comparisons, and John O'Keefe was included as one of the contributors.
Okay, so John O'Keefe was a contributor of DNA to his own long sleeve shirt, correct?
Based on the descriptions, correct.
All right, and whose other DNA was on that shirt?
I don't know.
And then finally, with regard to 7-18.17.1, that was an unstained area of the exterior of that shirt, correct? That same long sleeve shirt.
Correct.
And you tested that and got a DNA profile, correct?
Correct.
How many contributors were there to that DNA profile?
I interpret it as 2 contributors.
Was John O'Keefe one of them?
He was included as one of the contributors.
Okay, so his DNA was found on his own shirt, correct?
Based on the description, correct.
And who contributed the other DNA profile to John O'Keefe's sweatshirt?
I don't know.
With regard to any of the stains on the upper right leg of the jeans, I counted 1, 2, 3, 4, 5 that you've discussed here today. Were you ever asked to compare the DNA profile with the DNA profiles of either Brian Higgins or Brian Albert?
I was not. Oh,
sorry.
And your answer was you were not?
I was not.
Did anybody ever provide you with DNA profiles of Brian Higgins or Brian Albert?
Sustained today.
I may have one moment, Judge.
Yes.
It's a lot of DNA from a lot of people. And did they get any DNA off the car? Nope.
I just have one more question for you, Mr. Porto, and I do want to thank you for answering all my questions here today.
Morning,
You
Mr. Brown.
wrote reports on your analysis of all the items and the work that you did on this case,
I did.
and you are directed pursuant to protocol to address those reports to somebody, correct?
Correct.
Who was it that you sent the reports to in this case?
I'm sustaining the objection.
Did you send those reports to Michael Proctor?
Sustain. Jurors, strike the question.
I have nothing further. Thank you, sir.
Yes.
Happy Friday, Mo. Good to see you.
Mr. Porto, based on your training and experience and years of doing DNA testing at the lab, when it comes to samples from items of clothing, is it uncommon or common to have multiple contributors?
That depends. It can happen, but it's possible, yes.
Is it something that's a complete anomaly?
I wouldn't say so, no.
Now, turning your attention back to item 3-1.1, that's the sample from the passenger side tail light of the defendant's vehicle, correct?
Correct.
And Mr. O'Keefe was found to, his known DNA profile was found to be an inclusion for the DNA profile from the swab from the defendant's passenger side tail light, correct?
He was included in the profile, yes.
And to what statistical, what is the number associated with that inclusion, sir?
The DNA profile from this item is 510 non-alien times more likely to have it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown
Two
unrelated
unknown individuals.
Now, Mr. Porter, if I could turn you back to number 10 in your report, there's a number of different items listed there, correct?
Correct.
And as far as the items listed associated with various stains on various areas of Mr. O'Keefe's orange T-shirt and gray long sleeve shirt, there's about 13 different DNA profiles that you generated in reference to those items, correct?
Correct.
And from those 13 different items, they're all from a single contributor, is that correct?
Correct. They were interpreted as originated from a single contributor.
And as far as the DNA profile, your comparison of each of those 13 different stains on the orange T-shirt and the gray long sleeve shirt, what were your conclusions again as your comparison with the known standard of John O'Keefe?
Yeah, so the profile was interpreted as originated from a single contributor, and the DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
And lastly, with reference to the fingernail clippings from both the right hand and the left hand of Mr. O'Keefe, those were also, your analysis provided for inclusion.
Keep your
of Mr.
DNA to
O'Keefe's
yourself.
known
I
DNA
agree.
finger, correct?
He was included in the profile, correct?
And again, the profile from both the right hand and the left hand fingernail clippings was a single source contributor, correct?
Sustained.
How many sources were associated with those?
Objection.
Sustained.
Nothing further.
Okay. You all set, Mr. Yannetti?
Yes, Your Honor, thank you.
You are all set, Mr. Porto.
Thank you.
very much.
All right, shout out to Mr. Porto.
Who's the next witness?
There's a ton of DNA on John. Keep it moving.
Call Ashley Valier to stand.
Okay.
Oh, I wonder how Ashley spells her name. So many ways to spell Ashley.
Jim.
And who is she? You say Valier? How do you spell that? Shout out to the one black sister
You solemnly swear the evidence given to the court and jury in the case
in
that
Boston,
you answer the truth,
Massachusetts.
the whole truth, and nothing but the truth, so help you God.
I do.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, Ms. Valier. Could you
V-A-L-L-I-E-R.
please introduce yourself to the jury, spelling your last name for the court?
My name is
She works
Ash
for the crime
Valier,
lab.
spelled V-A-L-L-I-E-R.
And where do you work?
I work at the Massachusetts State Police Crime Laboratory.
And where did you go to school?
I got my bachelor degree in biochemistry and cell biology from UC San Diego, and a master degree in biomedical forensic sciences from Boston University.
Nice.
Now, following your education, where did you go to work from there?
Directly after I got my degree at Boston University, I worked at the Broad Institute.
Is that a dog?
What did you
barking?
do at the Broad Institute?
I did quality control checks of items that potentially could be tested for pharmaceutical use.
Now, how long have you worked at the Massachusetts State Police Crime Laboratory?
A little over 6 years.
Now, is the state lab accredited?
It is.
And by whom?
ANAB.
And what does ANAB stand for?
It stands for ANSI National Accreditation Board.
And the ANSI within the ANAB, what does that stand for?
That is another acronym that I don't recall right now.
Now, as part of that accreditation process, do you undergo any sort of type of proficiency testing?
I do.
And can you explain to the jury what that proficiency testing process consists of?
A proficiency test is a test that is given from an outside agency in the discipline that you do casework in, that you would work through like a normal case, but it has an end expected result at the end.
And how often do you undergo proficiency testing?
Every year.
And what areas do you specifically undergo proficiency testing in?
I've done proficiency tests in gunshot primer residue and physical match analysis.
And have you successfully completed each of those proficiency tests that you've taken?
I have.
Now, when you initially joined the State Police Lab, what was your position and title that you were hired for?
I was hired as a forensic scientist 1.
Now, can you please explain to the jury what your duties and responsibilities were as a forensic scientist 1?
So a forensic scientist 1 is the introductory level. It's when you start your training in whatever discipline you're going to be trained in and quality control checks. After you've been at the laboratory for over a year and you're signed off to do casework, you become a forensic scientist 2.
And you're currently a forensic scientist 2, is that correct?
Yes.
What is the difference between a forensic scientist 1 and a forensic scientist 2 at the Massachusetts State Police Crime Laboratory?
Good question.
A forensic scientist 2 has been at the lab for over a year and can do casework.
Now, just in general terms, what does the trace unit do or examine within the State Police Crime Laboratory?
I'm a part of the Trace Arson and Explosives Unit. So we analyze a wide range of pieces of evidence. So trace covers a lot of small things. So paint, fibers, glass, gunshot primer residue, physical matches. Arson covers fire debris evidence, and explosives covers explosives.
Now, specifically with reference to physical match analysis, can you explain to the jury, just in general terms at first, how was that analysis performed?
So physical match analysis is piecing broken things together to see if they were at once a single item.
Ooh,
Generally,
did they do that
you
with
look at the
taillight?
questioned item first, the item that you don't know specifically where it came from. Look at that, and then you would look at the known item, which is an item with a known source, like specifically like this window or like this vehicle. They're analyzed at separate times, and then if it looks like there could potentially be a physical match, you would analyze them together and see if they have a mechanical fit.
Now, when you retrieve items just in general to do some sort of physical match analysis, where do you get those items from?
We have evidence storage locations at the laboratory.
And how are they typically packaged when you receive them?
They can be packaged in cardboard boxes, brown paper bags, heat-sealed plastic bags. It depends on the individual items.
And when you're doing this analysis as far as the physical match analysis, what do you do to your bench between your examination of separately packaged items?
I mean, before I do any analysis, I bleach my bench, clean my tools, and then put down a fresh sheet of butcher paper.
And why do you do that?
To make sure everything's clean.
Now, again, speaking more in general terms, on what types of evidence can you perform a physical match analysis?
Sorry, can you repeat the question?
Sure. In general terms, with your work within the lab, on what types of items can you perform a physical match analysis?
A lot. Anything that has a broken or irregular edge.
Would that include glass?
Yes.
Would that include plastic?
Yes.
What are some of the other things that would also include?
Any sort of like polymer, metals.
And when you're doing a physical match analysis, what instruments do you utilize in the course of that analysis?
Generally, I'll use a stereo zoom microscope. Depending on the size of the items compared, I can use other microscopes as well.
Now, what is a stereo zoom microscope?
A stereo zoom microscope is a microscope that's mounted on a stand, so it gives a wider range of view that you can look at larger items.
Okay.
And how are you using that specifically in your physical match analysis of, let's say, items of plastic?
I'll use it to look at the edges and see if there's any like defining characteristics along those broken edges.
Now, as you're going through your analysis, do you document your work as you go?
I do.
And how do you do that?
With handwritten notes and with photos.
Now, at some point were you assigned to perform some work on lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes.
And what type of work were you assigned to do in this case?
I was asked to do physical match analysis, and then later on I was asked to look at, do some trace recovery, look at some debris.
Starting with the physical match analysis, how many different items approximately were you asked to look at?
Over 10?
Several, fair to say?
Yes.
Okay. And how were each of those items packaged when you received them?
So the questioned items were packaged first in a large paper bag, and then each item was individually packaged in a smaller brown paper bag within that container.
Now, again, just in general terms, because you've used it a couple times, when you say questioned item versus known item, as it pertains to this analysis in this case, what were the questioned items generally, and what was the known item?
The questioned items were items labeled as coming from a road, and the known item was labeled as coming from a taillight from a vehicle.
So what are the items
in
from
this
the
case,
road?
did you perform your physical match analysis in the same manner that you've previously described based on your education, training, and experience within the lab?
Yes.
Now, initially, you had examined some various plastic and glass items, and there was a drinking straw in there as well, correct?
Yes.
And specifically, as far as the item numbers that you looked at in this physical match analysis, could you provide the jury with a list of just the item numbers first to start with?
May
Your
I?
Honor.
Do you have your report with you, Ms. Willett?
I do.
Okay. Is there any objection, Mr. Nady, to using the report?
No objection at all.
So feel free to use your report.
Thank you, Your Honor.
So the questioned items labeled as coming from the road were item 7-5, item 7-6, 7-8, 7-9, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, 7-16, and 7-19. And the known item labeled coming from the passenger side taillight is item 3-1.
Now, Ms. Valier, within those specific item numbers of how things are labeled at your lab, if there are different pieces associated with the same item, how is it that you labeled those, specifically in this physical match analysis here?
So some of the items had multiple pieces within that item, so I labeled them A, B, C, etc., depending on how many pieces there were.
Now, if you could, please explain to the jury just, again, the process that you followed in your examination of each of those items.
So first I looked at the questioned items, the items labeled as coming from the road. I looked at,
Celtics played tonight, too.
documented the overall package because they were all packaged in the same container, the same brown paper bag. Documented that individually inside of it, there were a bunch of individual brown paper bags. Documented that, and I went one at a time through them, opening each paper bag, taking written notes, taking photos of the items inside. Within each item, I looked to see if any of those pieces fit together.
Okay. We'll be fine.
I cleaned my bench in between the items.
She's a professional puzzler.
Your Honor, may I approach?
Yes.
Not bad.
And Your Honor, so the quotes I've shown Mr. Yannetti all in advance.
Okay. Is there an objection to any of them,
There is
Mr.
no
Nady?
objection, Your Honor.
All right, so why don't we just go ahead and mark them all for...
Mock 'em. Mock 'em.
Your Honor, if I could, I was going to take them item by item.
Okay, that's fine. Okay.
Ms. Blair, I'm showing you 4 photographs. You recognize those?
I do.
What do you recognize those to be?
These are photos that I took of item 3-1.
And again, what was the description associated with item 3-1?
Passenger side taillight.
And was that description further given sort of a specific vehicle or a license plate associated with the vehicle that the taillight came?
It does. Massachusetts 3GC684.
Your Honor, the Commonwealth will seek to introduce in a minute the next exhibit A through D.
Right, those are covered. That's why I wanted to just mark them all because they're all
That's fine. If the court prefers, I can provide them.
Exhibits 170A through 170D.
May I approach with the remainder, Your Honor?
Yes. If you have them in sections, we can do that.
This way, I'm showing you two more photographs. Just ask if you recognize those.
I do.
And what do you recognize those?
Photos I took of item 7-5.
And again, from your report, what was the description in reference to item 7-1?
Yeah.
Thank you. You're fine. It's just allowed. Yes.
Okay. Piece of plastic, red, recovered from 34 Fairview Road.
And you're on the Commonwealth to seek to introduce and admit as the next exhibit A and B.
Okay.
Exhibit 171A and B.
My apologies, Your Honor. With the court's permission, may I publish some of those
Yes.
photos to the jury? Ms. Gilman, if I could first ask for photograph 2122. And Ms. Blair, what's up on the screen, that is the bag associated with the passenger side taillight or the known item, correct?
Correct.
And Ms. Gilman, if I could have photograph 2125. And Ms. Gilman, if you could just enlarge a little bit towards the bottom where the ruler is. Now, Ms. Valier, what's up on the screen now as far as the sort of notations there? Who made those?
I did.
And how do you know that you were the one who made those?
That's my handwriting, and those are my initials.
So the AMV is for your name, correct?
Yes.
And with respect to each of the items that you photographed, you had photographs that were taken of sort of what was in the evidence bag in total, displayed on your table that you would clean with the solution and everything else, correct?
Yes.
Okay. And Ms. Gilman, if you could just zoom out a little bit to show the item. And again, what's up on the screen, that is item 3-1, the known item as far as the tail light from the defendant's vehicle.
Yes.
I want to see if she was able
And
to put it
Ms.
back
Gilman,
together.
if I could have 2126. And Ms. Valier, if you could just describe for the jury what are we looking at in this photograph.
Those are those same items, just turned over.
And lastly, for this set, Ms. Gilman, if I could have 2135. And again, same item as far as 3-1, the tail light taken from the defendant's vehicle.
Yes.
Ms. Gilman, if I could ask for photograph 1905. And Ms. Valier, as far as with each of these items, you take photographs when they're inside the bag and then once you take them out of the bag, correct?
Yes.
Okay. And Ms. Gilman, if I could have photograph 1908. And what are we looking at in this photograph?
The contents of item 7-5.
May I approach again, Your Honor?
Yes.
We'll give you two more photographs. Do you recognize those?
I do.
And what do you recognize those?
Photos of item 7-6.
And that's one of the bag and then one when the item is taken out of the bag. Is that correct?
Yes.
And what was the description for item 7-6?
Piece of plastic, clear, recovered from 34 Fairview Road.
And appreciate those. Your Honor, Commonwealth will seek to introduce in a minute as the next exhibit, A and B.
Okay.
172A and B.
And with the court's permission, may I publish those to the jury?
Yes.
Ms. Gilman, if I could have photograph 1921. And then photograph And what's depicted up on the screen is that what you just have before you as the photograph that you took of item 7-6 recovered from 34 Fairview Road.
Yes.
Thank you. May I approach the witness again, Your Honor?
Yes.
Two other photographs. Review those. Can you recognize those?
I do.
What do you recognize as?
Photos I took of item 7-8.
And one of the bag and then one of the items removed from the bag, is that correct?
Yes.
And what is the description associated with item 7-8?
Piece of plastic, red and clear, recovered from 34 Fairview Road.
Call multi-seek to introduce in the minutes the next exhibit, A and B. And Your Honor, with the court's permission, if I could publish those to the jury.
Yes. Exhibits 173 A and B.
Ms. Gilman, if I could have photograph 1931 and then 1934. And Ms. Gilman, if you could zoom in just a little on those items, please. And Ms. Lair, again, what are we looking at in this photograph of item 7 dash? Oh, what are we looking at again in this photograph? Excuse me.
Photos of item 7-8.
May I approach the witness again, Your Honor?
Yes.
Were they plastic or glass?
Two other photographs. Those. Can you recognize those?
I do.
And what do you recognize those?
Photos of item 7-9 and 7-19.
And as far as the first photograph, as far as the bag, and then second with the items taken out of the bag, is that correct?
Yes.
So 7-9 and 7-19 were contained in the same bag?
They were. I then separated them into two separate packages.
And as far as 7-9 and 7-19, respectively, if you could tell the jury what was the description for each of those items.
Item 7-9 was pieces of glass recovered from 34 Fairview Road. Item 7-19 is trace item, black straw, recovered from 34 Fairview Road.
Your Honor, will seek to introduce in the minutes the next exhibit, A and B. May I publish, Your Honor?
Hold on.
Oh, forgive me.
74A, 174B.
Now you can publish.
My apologies. Ms. Gilman, if I could have 1958, please. And then 1962. And again, Ms. Lear, what are we looking at in this photograph?
The contents of that bag, item 7-9 and item 7-19.
May I approach again, Your Honor?
Yes.
Two other photographs. Do you recognize those?
I do.
And what do you recognize as?
Photos of item 7-10.
And again, one of the bag and one of the contents of the bag. Is that correct?
Yes.
And if you could, please tell the jury what was the description for item 7-10.
Piece of plastic, red, recovered from 34 Fairview Road.
I'm about to seek to introduce in a minute the next exhibit, A and B.
Exhibits 175A.
Let's get to it. Was she able to reconstruct it or not? Dang.
May I publish that for the jury, Your Honor?
Yes.
Ms. Gilman, if I could have 1952. And 1956. And again, Ms. Blair, what are we looking at in this photograph?
Photo of item 7-10.
Thank you. Gilman, you can take that down. May I approach the witness, Your Honor?
Yes.
Two other photographs. Do you recognize those?
I do.
And what do you recognize those?
Photos of item 7-11.
And again, one photo of the bag and one photo of the items outside of the bag.
Yes.
And again, if you could, please tell the jury what the description is associated with items 7-11.
Piece of plastic, 6, red, clear, and black, recovered from 34 Fairview Road.
I'll call both the signatures produced and submit as the next exhibit A and B.
Exhibit 176, A and B.
And may I publish, Your Honor?
Yes.
Ms. Gilman, 1979 and 1982. Again, Ms. Valier, I'm sorry, Ms. Gilman, if you could zoom in just a little on the items themselves. And Ms. Valier, what are we looking at in this photograph?
Photo of item 7-11.
These are photos, again, that you took in the lab during the course of your comparative or physical match analysis, correct?
Yes.
May I approach again, Your Honor?
Yes.
Two other photos, we could look at those. Do you recognize those?
I do.
And what do you recognize those?
Photos I took of item 7-12.
And again, photograph of the bag, photograph of the items outside of the bag.
Yes.
And if you could, please tell the jury what's the description of item 7-12.
Trace item, 14 glass and clear plastic, recovered from 34 Fairview Road.
Now, the Commonwealth will seek to introduce in minutes the next exhibit, A and B.
Exhibit 177A and 177B.
Your Honor, may I publish?
Yes.
Ms. Gilman, if I could have photograph 2015 and 2018. And again, Ms. Gilman, if you could just zoom in a little on the items.
Can y'all imagine how stressful it would be having to put
Thank you.
this stuff back together?
Ms. Valier, again, can you describe what's depicted up on the screen?
A photo I took of item 7-12.
Your Honor, may I approach?
Yes.
Two other photographs. Do you recognize those?
I do.
And what do you recognize those?
Photos I took of item 7-13.
And again, one of the bag and then one with the items removed from the bag.
Yes.
And if you could, please tell the jury what is the description for item 7-13.
Piece of plastic, red and black, recovered from 34 Fairview Road.
I'll love to seek to introduce in a minute the next exhibit A and B.
Exhibit 178A and 178B.
I don't know why they always ask to approach too.
Your Honor, may I publish?
Yes.
Speed the judge's
Ms.
rules.
Gilman, 1997. And 2000. And again, Ms. Gilman, if you could, please zoom in on the items. Thank you. And Ms. Valier, directing your attention to the screen, can you describe for the jury what is depicted on the screen now?
A photo I took of item 7-13.
May I approach the witness, Your Honor?
Yes.
Two other photos. Do you recognize those?
I do.
What do you recognize that?
Photos I took of item 7-14.
And again, one of the bag and one of the item removed from the bag.
Yes.
And again, could you please tell the jury what the description is associated with item 7-14?
Pieces of glass recovered from 34 Fairview Road.
I want to seek to introduce as the next exhibit, A and B.
Exhibits 179A and B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2009 and 2012. And again, Ms. Gilman, if you could zoom in on the item.
That looks like glass.
And Ms. Valier, as far as what's depicted on the screen, again, if you could describe for the jury what that is.
A photo of item 7-14.
May I approach the witness again, Your Honor?
Yes.
other photographs, if you could recognize those.
I do.
And what do you recognize as?
Photos of item 7-15.
And again, one of the bag and one of the items taken from the bag, correct?
Yes.
And if you could, please tell the jury what is the description associated with item 7-15.
Piece of plastic, 3 clear and 5 red, recovered from 34 Fairview Road.
The problem will seek to introduce and admit as the next exhibit, A and B.
180A and 180B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2072.
Yes.
Yes.
And 2077, please. Again, if you could zoom just a little as far as the items are concerned. And Ms. Valier, what are we looking at in this photograph?
Item 7-15.
There she is. What's up, Grace?
May I approach again, Your Honor?
Yes.
Other photographs, do you recognize that?
I do.
What do you recognize that?
Photos I took of item 7-16.
And again, one of the bag and then one of the contents from the bag, is that correct?
Yes.
And if you could, please tell the jury what was the description associated with item 7-16.
Piece of plastic, red and clear, recovered from 34 Fairview Road.
I'm also seeking to introduce in the minutes the next exhibit, A and B.
Exhibit 181A and B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2036 and 2040. And Ms. Gilman, if you could zoom in just a little. Thank you very much. And Ms. Valier, if you could, please describe for the jury what we're looking at in this particular photograph.
This is item 7-16.
Ms. Gilman, you can take that down. Now, with respect to each of these items that you examined in your physical match analysis, again, as far as the process is concerned, with the questioned items, what are you doing with reference to each of those questioned items first?
First, I document them, as you've seen. I'll see if any of those within the item have a physical match with each other. And then I'll package that away and look at all the questioned items before I compare inter-questioned items to see if there are any physical matches in between all of the 7- items.
And as far as your notes are concerned, what is it that you're noting in reference to each of those items as far as what characteristics of the item are you taking note of?
I'll note the size, the color, and the material.
And what, if any, measurements do you take of each of those respective items as well?
I'll take the length and width of each item.
Now, with respect, starting with item 3-1, the passenger side taillight from the defendant's vehicle, sort of internally within that item 3-1, what did you conclude as far as your physical match analysis within that item alone?
Within item 3-1, I believe 4 of the pieces fit together.
And, Your Honor, if the witness may refer to her notes
Yes.
as to, thank you.
Yes, four of the pieces fit together within item 3-1.
And which 4 of the pieces?
Pieces A, B, D, and F.
And as far as the labeling of those pieces of an individual item, let's just start with item 3-1. A, B, D, and F, how are they labeled, and how do you sort of physically label those items?
We have a label maker in the lab, so I'll print out the case number, the item number, and then A, B, C, and my initials, and that goes physically on each of those items, or all of those pieces.
So if any of those items had a sticker on it with a letter or something associated with that, that would be something that you did during the course of your physical match analysis, correct?
Yes.
Now, if I could turn your attention to item 7-5, piece of plastic red recovered from 34 Fairview Road, what did you conclude as far as your physical match analysis just within that single item?
There was no physical match noted among those 3 pieces of apparent plastic.
And when you say no physical match found from the different pieces within that item, what does that mean?
The broken edges of each piece did not align.
So the broken edges of the individual pieces within item 7-5 did not fit together with the broken edges of pieces within item 7-5, correct?
Yes.
Okay. Now, with respect to item 7-6, a clear piece of plastic recovered from 34 Fairview Road, what did you conclude based on your physical match analysis just pertaining to that item 7-6?
So this item was 2 pieces of colorless apparent plastic, and there was no physical match noted between those two pieces.
Now, with reference to item 7-8, red and clear plastic recovered from 34 Fairview Road, what did you conclude in regard to your physical match analysis just with the pieces contained within item 7-8?
So there were 14 pieces. Pieces C and D fit together, and pieces E and F fit together.
And when you say fit together, is there a term of art used within your field called a mechanical fit?
Yes.
And can you explain to the jury what you understand that term to mean as far as what is a mechanical fit?
So a mechanical fit and a physical match are the same thing. It's when the broken edges align together to show that they were once a single item.
Now, if I could turn your attention to item 7-9, pieces of glass recovered from 34 Fairview Road. What were you able to conclude from your physical match analysis of just the individual pieces contained within item 7-9?
So this item had 3 pieces, and no physical match was found between those.
Turning your attention to item 7-10, red pieces of plastic recovered from 34 Fairview Road. What were you able, that is a single item, is that correct?
Correct.
So no physical match because there's nothing to match, it's just one piece, correct?
Correct.
Okay. And turning your attention to item 7-11, identified as 6 red, clear, and black pieces of plastic recovered from 34 Fairview Road. What did you conclude in regard to your physical match analysis just within those pieces contained within 7-11?
So that item had 6 pieces, and there was no physical match noted among those 6.
Now, turning your attention to item 7-12, which was identified as 14 pieces of glass and clear plastic recovered from 34 Fairview Road. Again, what did you conclude from your physical match analysis just from the various pieces contained within item 7-12?
So there were 14 pieces overall. Pieces B, C, D, F, and K fit together mechanically as one unit. And then pieces E and I fit together mechanically as one unit. And pieces M and N fit together mechanically as one unit.
Now, through your examination of
I want to know how precise
these
this
pieces in
science
particular
is.
and other pieces as well, did you note any debris contained on the pieces that you located?
Yes.
And can you say anything as far as what that debris was, or was there any analysis done of that debris specifically?
I just note that there was debris present, and I package it into a tin that's retained with the original packaging.
Now, turning your attention to item 7-13, that was a piece of plastic, red and black, recovered from 34 Fairview Road. Is that correct?
Yes.
And again, just with respect to your physical match analysis of the various pieces of 7-13, what did you conclude?
So that item had 3 pieces, and there was no physical match noted among those 3.
And again, with reference to item 7-14, piece of glass recovered from 34 Fairview Road, that was again a single item, correct?
A single piece, yes.
So I'll turn your attention to item 7-15, 3 clear and 5 red pieces of plastic recovered from 34 Fairview Road. Is that correct?
Yes.
And what were you able to conclude from your physical match analysis, again, just from the various pieces contained within item 7-15?
So there were 8 pieces in this one. Pieces F and H fit together mechanically.
Turning your attention to, lastly for this purpose, item 7-16, a piece of plastic, red and clear, recovered from 34 Fairview Road. What were you able to conclude from your physical match analysis just contained within the pieces of that single item 7-16?
So that item had 7 pieces. Pieces A, C, and D fit together mechanically.
Now, Ms. Valier, once you had examined each of those pieces individually, what did you do next in your analysis?
Next, I compared all of the inter-questioned, these items 7-5 to 7-16. I compared them to see if there was a mechanical fit amongst those, between those items.
Mr. Lally, is this a good place for our break?
It's perfect. Yes, Your Honor.
All right, jurors, we'll take our morning break. We'll see you back here in about 15, 20 minutes. Thanks for you can walk out.
And we're going to skip the whole break, by the way. But I'm going to read some super chats real quick.
Can I
First
see
of all,
counsel for a minute, please?
thank you to all 1,700 of y'all who are in the building. Thank you to everyone who's liked the video so far, too. My goodness. We got a couple of super chats I want to read. Shout out to Curious Coco New York says anything is possible. Talking about the, yep, exactly. The medical examiner. And it could be anybody. Basically sums up the Karen Reed case or the Commonwealth's case. I agree. Kara Hampton with the 5 bombs. She says, Kel Bell said there are 4 to 5 black jurors allegedly. Where did they find them at? They must have brought them in from Maryland or something. That's kind of crazy. Shout out to the black folks in the trial. We got some of them in there. Kim Dorsey is in here with the 5 bombs, showing some love just with the super sticker. Thank you so much, Kim. And then we got my guy, Mr. Brown, with the 5 bomb says, it's great to have family that care. Yep, we're praying for you, Mr. Brown. Appreciate you. Glad that you're in here and continue to recover well. It's always good to see you. I'm becoming a popular guy. No, we're just here. We're just consistent, you know? We are consistent. Now, Judge Bev wanted to see them at side-by, so let's see what this is about. Are we well, I don't know. Did she say side-by? Y'all make sure if you haven't yet, vote in that poll to see how many side-bys we're going to have today. It looks like a lot of you have voted. Most of you are saying we'll have 6 to 10. I don't know. We'll have to wait and see. Did she say side-by? Shout out to Amy with the banana. Thank you, Amy.
And can I see counsel for a minute, please?
I don't know if this is technically a sidebar, but let's go ahead and skip ahead and see what they talking about over here. Thank you, Amy, for the banana. Amy with the bananas. It's banana day. And the cake. Oh, she's ready for lunch already? Amy,
all right,
it's only,
Mr. Leslie, I'll hear you.
11:55.
You are unmuted.
Thank you, Amy. Nope, there's only one black person in all of Canton. There she is right there. Y'all
Thank
see
you,
her?
Your Honor. Yesterday, Your Honor discussed with the parties, and parties were heard with regard to the issues we have raised with regard to the timing of the May 8th report from Mr. Burgess that the defense received on May 11th. And what I wanted to do, Your Honor, is briefly provide the information Your Honor asked for yesterday, which was how much time we might need under various circumstances. And so I wanted to take a few moments to put that in context. It will only take me a brief amount of time to do so. So, Your Honor, there is a timing issue, but there's most importantly a substantive issue. I will not, of course, go into the detail of yesterday, but the timing really is informed by the substantive issue. And so, with regard to the matter, we went back and we looked at more deeply the effect of this timing and this movement of the what has been referred to as clock drift in Mr. Burgess's report that we got on May 11th. I spoke of the significance yesterday, and here's what I would like to add as is relevant to the time we're going to need. I again urge the court to reject it substantively, because what we did was we went and we looked at matters such as the cross-examination of a key witness in this case, Jennifer McCabe. She testified with regard to observing a vehicle at 12:45 a.m. And that's a significant point. I know I don't need to elucidate for Your Honor. All of this is going in significant part, if not total part, to what has been as alleged a collision here, which we vigorously contest. No collision ever occurred. But the timing of it, the timing of what's alleged by the Commonwealth is very important. The seconds are important. Literally 1 second can turn not only the Commonwealth's theory completely around in circles and debunk it, but also the jury's analysis of it. And this is the point I wanted to elucidate today, is that the jurors have been provided information, and the defense has aimed its defense on this claim based upon, in large part, timing. So now what we have is on May 11th, Mr. Burgess changing the timing. So what does it affect? Not only witnesses like Jennifer McCabe, who we crossed, we strategized with regard to, but also my decision to not even cross Trooper Garino, because Trooper Garino had testimony with regard to when Ms. Reed connected with the Wi-Fi at One Meadows, and there's a certain time associated with that. We have Mr. Whiffen, who went through, the Commonwealth went through a timeline, and we believe they went through a timeline for the theory that they had, and I cross-examined Mr. Whiffen extensively with regard to that timeline. There were several defense strategies and effectuations of strategies based upon that timing. So with regard to the substance, Your Honor, and there's more, but I think that's a fair representation. It innervates our entire defense. The question now of Your Honor of how much time it will take the defense to react to Mr. Burgess, I wanted to say it's not only a reaction, but it's a substantive defense analysis, and 3/4 of the effectuation of that has already occurred through our presentation in terms of cross-examination. So we would have to, and we're still evaluating that, revisit all of that. And secondly, we would have to put that into the calculation of all of our witnesses that we've already prepared that are based upon that timeline. So it is a very significant point, and to the extent that the Commonwealth tries to argue, well, you know, we never really committed that much to a certain time period. I again urge the court to look at the report of Dr. Judson Welcher, where he has 1162-2 with a specific range, 1238 to 43. And even in their range, it's a very small time, which further supports how each second matters in this regard. Now to the answer to the question Your Honor asked yesterday. Again, I urge that it just be rejected and we keep this trial moving in its current pace. To the extent that that does not occur, and again, we urge that it be rejected, the report, because it's a Rule 14 violation, there is no remedy for the defense. However, to the extent, and given Your Honor nonetheless asked me for an answer in time, we would need 4 days to be able to address it. We will not ever be able to recover strategically or substantively from it, given all that's been presented to the jury, and it will be very difficult to figure out how we're going to go present a defense after we've already presented to the jury our defense and our cross-examination. It's not really structurally possible to simply take 4 days and address Mr. Burgess, because we can't go back to all the witnesses I just mentioned and others and start crossing them and eliciting testimony with this new time period in mind. But I wanted to answer the question, Your Honor, respectfully. It would be 4 days for us to even go from where we are now and then try to alter not only witnesses such as Arca, but DeSogra and Gaffney and other types of witnesses that we have in that regard. So, Your Honor, respectfully, that is my response.
All right. Does the Commonwealth want to be heard?
I do.
Okay.
Sure they do.
Respectfully, Your Honor, the defense is very confused.
Oh, here we go.
Shots
Shots fired.
The issue. They attempt to confuse Your Honor about what the impact would be. This has never been a change. The government is not changing their timeline. The Commonwealth is not changing any information. The Commonwealth is not offering anything that affects in any way the testimony of witnesses. It's notable in the argument there is no relationship to the facts or the actual report that was provided. The Commonwealth has always provided the data, which they have, and they hadn't a chance to analyze. And the interpretation of the data has been different between the parties. We have been clear from the beginning at the time in which the infotainment system shows that there was a collision. We've been clear. And the data has been clear. That has never changed. That data in the telestream system is based on a clock in the Lexus, which both sides know full well is different than a clock in an iPhone. You can see all the productions of Dr. Welcher's PowerPoint presentation where it shows that time, 12:31:43, has never changed. Also, it has been clear that both sides appreciate that there is a variance between the clock in the Lexus, which leads to that system information, and a clock in an iPhone. In fact, the defense was so aware of it, they hired an expert, Mr. DeSorga, who gave his opinions about that variance. We have never suggested there was not a variance in this case. In fact, we have highlighted the variance. When their expert, Mr. DeSorga, provided a report, we believed that his analysis was wrong.
Uh-oh.
And so we looked at the variance and the data that was available from the Telestream system and John O'Keefe's Waze data that was on his phone that was always available to all of the experts in both sides. And when Mr. Burgess looked at the variance at the time of a three-point turn about 7 minutes before the collision,
He does not.
he simply matched the Waze information on Mr. O'Keefe's phone to that of the information from the Telestream and saw that it was a 21 to 29 second variance.
Oh, this is going to be
All
important.
that data was available to the defense because their expert made an improper conclusion is not our fault. This does not change the testimony of anybody.
Dang.
They point to Jen McCabe's text message where she said she thought she saw a motor vehicle out front that evening
Y'all give me
at
one sec.
12:45.
That is not consistent with the Commonwealth's timeline, but that doesn't change. That favors the defense. It does not change anything to do with ARCA. ARCA has not, as far as I've seen in any reports, ever talked about the variance, just Mr. DeSorga. And so because this is inconvenient for the defense, and because it further focuses the variance that we already discussed and provided, isn't a reason to exclude it. It's not late discovery. It's not a Rule 14 violation. It is further analysis of information that was already provided, opinions that were already provided, and it is in response to their experts' mistake about that variance. There's nothing new here. Nothing has changed.
Go right ahead, Mr. Leslie. The only question I had for you yesterday, for you to respond to today, was the time, so I gave you more leeway.
And you're giving me more leeway, and I appreciate it.
Go right ahead.
So, two items, Your Honor. As I alluded to yesterday, and it's been a point that Mr. Brennan just made, we believe strongly, Your Honor, that at a minimum there needs to be a voir dire of Mr. Burgess. And we believe strongly there needs to be a voir dire because we have a serious concern that the sequestration order has been violated. He has changed a very key aspect of this matter after the testimony of Mr. Whiffen, after Mr. Whiffen presenting a timeline. In his report, Mr. Burgess, his new purported report of May 8th, he references to align it with Mr. O'Keefe's cell phone. That is the essence of Mr. Whiffen's report, is anchoring in his timeline. He did a whole timeline on Mr. O'Keefe's report. And conveniently, the proposed alteration by Mr. Burgess in his report of this clock drift now makes it very, very close to fitting within Mr. Whiffen's timeline and the theory of the prosecution. At a minimum, we need a voir dire to ask Mr. Burgess, why did he do what he did? Another reason for the voir dire. Mr. Brennan yesterday said, we were surprised to get the report. That further makes great concern as to why Mr. Burgess did what he did. Lastly, Your Honor, with regard to Mr. Brennan's point, and he made it yesterday and I corrected it, he said it again today, that supposedly our witness, Mr. DeSogra, made an error and that we're trying to correct an error of Mr. DeSogra. That is incorrect, Your Honor. Again, Mr. DeSogra was responding to Mr. Burgess's report. Mr. DeSogra's report is entirely saying, okay, Mr. Burgess says this, and therefore the defense says this. Now Mr. Burgess is changing what he is saying. So it is completely incorrect to say that Mr. DeSogra is trying to correct an error. That would require, again, Mr. DeSogra to change what he has done. Final point is this. There was also an issue, Your Honor, in this.
Uh-oh, looks like we got a break in the feed. Hold on a second. I'll fix it. He is changing the timeline. How's that allowed? Don't get it. Give me... Oh no, I don't know what happened here. Hold on a second, guys. Let's see here.
Point is this.
There we go.
There was also an issue, Your Honor, and this is extremely important with regard to burden shifting. There's not only the question of should this be allowed at all, there's not only the question of how much time the defense will need, but there's a third and important issue, and that's burden shifting. What Mr. Brennan proposed yesterday was a very irregular process where essentially the Commonwealth gets 3 bites at the apple for a problem that they caused. The problem we're talking about is Mr. Burgess changing a significant part of a timeline. Yes, there was a variance that he had, but he picked a range of the variance. He's now changing the variance. So what the Commonwealth is proposing is that our witnesses go forward, the aperture gets to wait, they come on, and then the aperture gets to come on yet again. We would urge
I did not understand the Commonwealth asking me that. Are you asking me to do that, Mr. Brennan?
I appreciate the clarification.
I'm not sure what he's saying, so...
It sounds like DeBroja or whatever.
His name is DeSogra, yes.
DeSoder, You're suggesting that the Commonwealth suggested yesterday that he testifies first and then the aperture witnesses?
What I understood was going to happen is Mr. Brennan said yesterday that Dr. Welcher cannot come in until after.
No, I didn't understand that. I understood Dr. Welcher, Shannon Burgess, and then Dr. Welcher for everything that you folks received prior, January 31st or whatever the date was. And then potentially for all the new ARCA information that came in May 7th, that portion, Dr. Welcher returning on rebuttal for. Not that they were holding back Dr. Welcher completely. Is that correct, Mr. Brennan?
That's the conversation I had. That conversation I wasn't part of.
Yeah, I think you misunderstood that, Mr. Alessi.
So just so I'm clear, what is it that the rebuttal?
Mr. Brennan, all right, this is separate, and I'd really like to give everybody a break here. What is it the Commonwealth is asking to do regarding that?
Good question.
Regarding Mr. Burgess or Mr. Welcher?
Dr. Welcher.
Dr. Welcher should come in and testify to his PowerPoint, all of his opinions, which address all of the prior representations and opinions of ARCA, although we still don't have any raw information, but we're ready to move forward. Regarding any new opinions, which there is over a dozen new opinions that includes testing, video, experiments, Dr. Welcher should have enough time to review, conduct his own testing, turn it over, and then in rebuttal address limited to the new issues raised by ARCA.
That's how I understood it, Mr. Alessi.
And that's how
So they want to bring him in? They want to bring him back.
Now with the Burgess changing of the clock drift, how many times is the Commonwealth proposing that Dr. Welcher gets to come in and talk about that?
Right.
Is he just going to come in and talk about it?
So you talk with Mr. Brennan about that. All right, so I'm all set for this.
There are no changes. There is no changes in the timeline. He keeps trying to portray this as something has changed. Nothing has changed. It's the exact same. He's always said there's a variance. He's been looking into the variance for a long time, and now he has found a method to show the exact variance. It's not changing. There's nothing in the reports that changes as far as the timeline. That's just an attempt to cause fear. There's nothing that has changed. We can look at the reports. It's all the same, always has been, other than now he's identified the mistake of their expert, and that led him to be able to identify the variance, which is helpful and new. And the suggestion that there's been some violation of an order, no good faith basis whatsoever.
Does the Commonwealth oppose a voir dire just on that one issue?
Yes, because it's suggesting that there's a good faith basis for it. Nothing has. Ian Whiffin's report was available to the defense and our experts months and months and months ago. The issue of variance has been an ongoing issue for months. There's nothing that triggers a change in the testimony to adopt or adapt to it. Our timeline has been the same since when we turned it over at the beginning. They cannot point to one thing that has changed between
the jury's not in.
Dr. Welcher, Ian Whiffin, Jessica Hyde, or Shannon Burgess. They are just saying things without a good faith basis. In the reports, show us where something has changed.
Your Honor, to inform you, Your Honor, we would like to print the page in the clock adjustment because what Mr. Brennan said is
yes, and I'm happy to any information.
Thank you.
All
All right, there we go. Judge Bev needs her smoke break, so we're going to skip ahead.
All right,
Thankfully,
quick
we've got
please.
some delay. Oh, man, that got rid of... I thought we were going to be good for lunch. They took forever on this break. Jeez, man. All right, let's get back to it. Hold on. They stole all of our delay. Good Lord. I thought we were going to be able to skip through most of lunch.
Thanks, Chrissy. All right, so Mix Valera, I'm going to ask you that you speak right into your microphone when you answer, if you could, please.
Okay.
Thank you.
Move that mic up.
All right, Mr. Lally, go right ahead.
Thank you, Your Honor. Now, Ms. Clear, we talked about sort of the physical match or mechanical fit analysis that you did with regard to each of the items individually, correct?
Yes.
And can you explain for the jury the process that you undertook in your physical match analysis between different item numbers?
So between different items, amongst the questioned ones, I only compared the pieces that were large enough to have a label on them. Some pieces were quite small. I utilized several benches and divided them up into sections for each item, and individually pulled out all of those pieces. And then I had another bench where I did the actual comparison. I started with all the pieces of the same color and looked to see if any of those had potential edges that could match.
Now, with respect to items 715 and 716, did you do a physical match analysis between those two separate items?
May I look at my notes?
Yes.
Okay. Yes.
And what, if any, conclusions did you come to in relation to your physical match analysis between item 715 and item 716?
Two pieces from item 7-15, F and H, fit mechanically with two pieces from item 7-16, F and G.
And what, if any, conclusion were you able to draw with reference to the physical match between pieces from item 715 and pieces from item 716?
Those four pieces were at one time together as part of a larger unit.
Now, Ms. Verlier, what physical match analysis did you do with reference to items 7-6 and 7-11?
So one piece from item 7-6, piece B, fit mechanically with one piece from item 7-11, piece D. So those two pieces were at one time together as a larger unit.
And Ms. Verlier, with reference to items 7-8, 7-9, and 7-16, what, if any, conclusions were you able to draw from any physical match analysis you did between pieces from those three items?
So two pieces from item 7-8, pieces C and D, one piece from item 7-9, piece A, and one piece from 7-16, piece E were found to have a mechanical fit. So those pieces were at one time together as a larger unit.
Lastly, for this section, at some point did you do a physical match analysis for the glass pieces in items 7-12 and 7-14?
Yes.
And what conclusions were you able to draw from your physical match analysis between 7-12 and 7-14?
There was no physical match between the glass pieces from, or apparent glass pieces from 7-12 and the glass piece from item 7-14.
She's
now,
doing
Ms.
great
are you
compared
aware
to the other witnesses
that there was an additional
had.
analysis that was done with respect to glass pieces and other glass pieces that you didn't examine in your analysis at your lab?
I know that there was other trace work done. I'm not sure exactly what the work was.
Okay. And do you know who performed that additional trace work?
Christina Hanley.
And who is she to you as far as in reference to your work at the lab?
She's my supervisor.
Now, with regard to each of these items individually, they came as labeled in individual bags as we demonstrated on the screen, correct?
Yes.
Okay. And with respect to those bags, did you note any particular date associated on the front of those bags?
That's documented in my photos.
And all I'm asking here is that with respect to each of those bags of items, whether they be 3-1, 7-4, 7-5 or 6 or 8. Many of those bags had different dates on them, correct?
Yes.
Okay. And when you received those items in that bag, you essentially removed the items from those individual bags, placed them on the table, and examined them, correct?
Yes.
And that examination included a microscopic examination?
Yes.
Now, with respect to any of those items, there were some items that pieces within the same bag that had the same date on that bag did not fit together mechanically, correct?
Yes.
However, there were items from one bag collected on one date that did fit mechanically with items from another bag collected on another date. Is that correct?
Yes.
Now, if I could turn your attention to item 3-1. Again, for the jury, what is the physical description associated with item 3-1?
Item, passenger side taillight, Massachusetts 3GC684.
Now, did you perform a physical match analysis with pieces from item 3-1, 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16?
I compared them, yes.
And what, if any, conclusions did you come to from your analysis, your physical match analysis between item 3-1 and all of the items beginning with the number 7?
There was a physical match with, do you want me to list?
If you
all
could,
of them?
please.
Okay. So 2 pieces from item 7-5, 4 pieces from item 7-8, 1 piece from item 7-10, 4 pieces from item 7-11, 2 pieces from item 7-12, 2 pieces from item 7-13, 4 pieces from item 7-15, and 4 pieces from item 7-16 were found to fit mechanically with item 3-1.
Okay.
And what, if any, conclusions were you then able to draw from your physical match analysis between item 3-1 and each of those respective items beginning with the number 7?
Those pieces were once together as part of a larger unit.
May I approach, Your Honor?
Yes.
Mayor, I'm showing you 3 additional photographs. Do you recognize what's depicted in those?
I do.
And what do you recognize those?
This is a comparison between item 3-1 and those pieces from all of the other pieces.
Your Honor, I'm called to seek to introduce and admit as the next exhibit A, B, and C.
Is there any objections to any?
No objection, Your Honor. Thank you.
182, A, B, and C.
And may I publish, Your Honor?
Yes.
Ms. Gilman, if I could have photograph 2096. And Ms. Gilman, yes. If you could even zoom in just a little bit more on the item itself. Ms.
So you did reconstruct it.
What are we looking at in this photograph?
I wonder how long it took.
Those pieces that I labeled from item 7 all of those, they all fit together mechanically into this piece.
And as far as earlier you were testifying as far as the label maker and the different various pieces that you would label throughout the process of your physical match analysis. Do you see these in this photograph as well?
I do.
And where are they located with reference to the reconstructed piece above?
They're those little white rectangles on the piece.
So what's depicted here is the mechanical fit between items 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16, correct?
Not items 7-8 and 7-14, but the other ones, yes.
And why not those two?
They didn't fit mechanically with
There you go.
the other pieces.
Not that complicated.
Ms.
They
Gilman,
didn't
if I
fit.
could have 2150. And again, if you could just zoom in a little. And Ms. Valier, what are we looking at in this photograph?
So on the right side was that piece that was just shown, and on the left side is item 3-1.
And lastly, Ms. Gilman, if we could have 2151. Again, if you could zoom in on that item just a little. And Ms. Valier, what are we looking at in this photograph?
So that's that right piece on top of the tail light from the previous photo.
And is this the mechanical fit that you were testifying about earlier with reference to item 3-1, the taillight housing, and all of the various pieces that were found at 34 Fairview, starting with the number 7?
Yes.
Thank you. Ms. Gilman, you can take that down. Ms. Valier, lastly, in reference, did you also receive some debris from John O'Keefe's clothing?
Yes.
And Mr. Officer, we can have the lights back on. Thank you very much. And what did you find contained within that debris from John O'Keefe's clothing?
So it was 5 different items. So it was debris collected from, labeled as coming from the clothing. There was mostly debris, some apparent fibers.
Were there any pieces of apparent plastic contained within the debris?
Yes.
Was there dirt contained within the debris?
Yes.
And that debris was labeled as an item 17-18.18, is that correct?
I believe so.
And what is it that you did with the debris from the gray long sleeve shirt and the orange t-shirt?
So those were all packaged in like glassine folds. And I looked through it and documented it.
When you say you documented it, did you look at it under a microscope?
Yes.
So you did an examination under a microscope, is that correct?
Mm-hmm.
Yes.
And did you measure some of those items contained within the debris?
Yes.
Specifically, did you measure items of apparent clear plastic contained within the debris?
Yes.
And what did you measure those items to be?
The piece of clear apparent plastic was approximately 1/8 inch by 1/16 inch.
And once you had conducted your preliminary analysis of those items, where did those items go?
I did no further examination on this myself. Christina Hanley might have examined some of these further.
Thank you.
Yeah, I mean,
I
you
have
did
nothing
say.
further.
Yep.
Ms. Giannetti?
Thank you very much.
Good afternoon.
Good afternoon.
I'd like to first talk fairly briefly about your reconstruction of the taillight to which you've testified. At the outset, by the way, that was item 7-3.1, am I correct?
Sorry, for which one?
That's the taillight, this 7-3.1, am I correct?
3-1, I believe.
7-3-1?
The taillight is item 3-1.
Oh, 3-1. I'm so sorry. Okay. With regard to that particular item,
We're gonna get there.
Your lab has different departments, correct? Criminalists who do different things, correct?
Yes.
You are aware that there are scientists within your lab who do DNA analysis, for instance, correct?
Yep. Yes.
And with regard to the order of processing items, is the DNA analysis done before or after you get the item?
It's usually before.
Okay. In this case, it was before. Am I correct?
I believe so.
Were you made aware that there were 3 contributors of DNA to that taillight, 3-1?
I'll allow it. When you made aware of that.
No.
Once you reconstructed the taillight, you'll agree with me that it was missing a piece, correct, or pieces?
There was an empty spot on the overall reconstruction, yes.
Were you ever provided with any pieces of taillight that would have filled in that missing spot?
No.
Were you ever provided or told about any pieces recovered from 1 Meadows Ave in Canton?
No.
Were you ever told about a collision at 1 Meadows Ave in Canton?
Sustained.
In any case, you'll agree with me there was no glass in that taillight at all, correct?
Within the taillight, I classified them as apparent plastic pieces.
There's no glass as part of the taillight, correct?
It's not made out of glass. That's what he's trying to ask.
I mean,
Is
it
the
depends on
taillight
what you
made out
call,
of
like,
glass?
the bulbs usually have glass as far as I'm aware.
Those are very, very thin glass, though, correct? Those bulbs?
Yes.
All right. Now, your lab received clothing in connection with this case. You've
Answer the
testified
question,
to that,
Ashley.
correct?
I received the debris labeled as coming from the clothing. I never saw the clothing at all.
Right, but you're aware that your lab received clothing before the debris got to you, correct?
Yes.
And your understanding was that that was John O'Keefe's clothing in which he was found on January 29th of 2022, correct?
It's labeled as coming from him. I'm not sure of the date that it was found.
Okay. You understand the procedure of that goes on at your lab when it receives evidence?
Yes.
And you know that once clothing is brought to your lab, it's given evidence numbers, correct?
Yes.
And then one of your colleagues at the lab handled the clothing and or examined it, correct, before it came to you?
Yes.
And your understanding is that one of your colleagues retrieved debris from those items of clothing and then packaged it in a fold before it got to you, correct?
Yes.
You then open up the fold and you look at the debris, correct?
Yes.
You never saw that debris inside the clothing, correct?
Correct.
And the pieces of clothing that come in are given evidence numbers when your lab receives them, correct?
Yes.
For instance, the orange T-shirt was given or was named item number 7-17,
Yes.
and the gray long sleeve shirt was item 7-18, correct?
Yes.
And your lab is accredited, correct?
Yes.
There is a complete chain of custody from the moment the clothing was brought to the lab to when the debris was removed from the clothing, ultimately to when you're in court today handling the items, correct?
Yes. Our in-lab chain of custody extends from when we receive it to when the submitting agent it is returned to the submitting agency.
Okay. And you have complete confidence that the chain of custody at your lab is effective at making sure that the evidence does not get lost or mixed up or contaminated, right?
I mean, the chain of custody is meant to track where a piece of evidence is. The evidence unit also does inventories and audits to make sure that things are where they're supposed to be.
And you have confidence in your lab's chain of custody policies and procedures, correct?
Yes.
But you'll agree that your lab cannot control who handled the clothing before it arrived at your lab, correct?
Yes.
There are times in which crime scene technicians or criminalists from your lab actually participate in the search for evidence at a crime scene, do they not?
Some of the people at the lab are crime scene responders, yes.
There are times when they actually take custody of evidence. Again, I'm talking about people from your lab, professionals. They take custody right from the crime scene and transport that evidence to your lab, correct?
Yes.
In those circumstances, your lab would have a complete chain of custody from discovery to seizure to testing or whatever comparison you're doing until you release the items, correct?
Yes, but the electronic chain of custody doesn't start until that item is entered into our LIMS system at the lab.
Right, but when it's entered in, it would be entered in as having been seized by somebody from your lab, correct? In the hypothetical that I'm giving you.
Yeah, there's an evidence submission form that says that this crime scene responder submitted it to the laboratory.
There are other cases, however, when the evidence is brought to your lab by the police, correct?
Yes.
Local departments have access to your lab?
For evidence drop-off, yes.
The state police have access to your lab for evidence drop-off?
Yes.
And in this case, it was not a criminalist or other professional from your lab who seized the clothing and brought it to your lab, correct?
I'm not sure.
Do you have a record of that in your report in terms of who it was that brought the material to your lab?
I could look at the evidence submission form to see who.
With the court's permission?
Yes. Okay.
Hold on. Is this our first sidebar?
Okay.
There it is. We got our first one. Finally. Wow, I'm shocked. Team 0 to 5 might have it today. That's our first sidebar of the day. Let's go ahead and skip ahead. This reconstruction is interesting stuff.
I do.
All right, go ahead, Mr. Manning.
Having reviewed your reports, can you testify to the jury about who it was that brought this evidence into the lab?
Yes, we're live. We're just a little bit behind.
You can tell us.
Okay. So submission
10 minutes
7, all
behind.
the items that are 7-, was submitted by Trooper Michael Proctor.
Oh, no, not this guy again.
Were you aware
Tomatoes
of
in
the
the
date
chat for
of the
Michael
incident
Proctor.
that gave rise to this case?
Yes.
And what was that date?
January 29th, 2022.
Were you aware that the clothing that you received was seized from the Good Samaritan Hospital that very day?
No.
What date was the clothing brought to your lab?
March 14th, 2022.
So that means that your chain of custody at the lab began on March 14th of 2022, correct?
Yes.
And would you agree with me that was about 6 weeks after the date of the incident, January 29th of 2022?
Yes.
And of course, you can't speak to the chain of custody from January 29th to March 14th of 2022, correct?
Correct.
And you have no information and do not know why Michael Proctor waited 6 weeks to bring this clothing to your lab, do you?
Sustained.
Do you know where Michael Proctor
It was
stored
6
this clothing
weeks?
during that 6 week period?
No.
In his
Do you know
trunk
how often he was alone with access to the clothing during that 6 week period?
multiple times.
Do you know if he had access to pieces of red or clear taillight during that 6 week period?
Objection, strike out.
Sustained. Move on, Mr. Manning.
You got your point across. We know Proctor was a, you know what?
You were not present when the clothing was seized, correct?
Correct.
You did not have custody of this clothing from January 29th of 2022 to March 14th of 2022, correct?
Correct.
You do not know what was done with the clothing before it arrived at your lab, correct?
You've covered this, Mr. Manning. Move on, please.
One last question.
Okay.
You cannot vouch for how the clothing or taillight pieces were handled before they got to your lab, correct?
I cannot.
Anything further, Mr. Lally, or are you all set? I'm not curbing it.
No. Very, very.
Mr. Blair, there is a separate evidence unit contained within the Massachusetts State Police Crime Laboratory, correct?
6 weeks
Correct.
to sit on evidence
And
is
fair to say
crazy.
you have absolutely nothing to do with that, correct?
I'm not a part of that unit.
And so your responsibility as far as chain of custody is concerned is from when you retrieve the item during your analysis and then when you return the item to the evidence unit, correct?
Correct.
And from that analysis that you performed, you found that there were 10 different items, starting with the number 7, that were a mechanical fit to 3-1, the taillight housing from the defendant's vehicle, correct?
If it's 10 items, I don't have. I can count them.
As far as
said, "I
all
don't know."
those items beginning with 7 that you went through or elucidated on your
She's
direct
trying.
examination, each of those were a mechanical fit to each other and then to the taillight housing in 3-1.
The pieces that were previously stated, yes.
Nothing further.
All right. All set.
All right, shout out to Ashley. Oh my God, it's rough, man.
All right, so jurors, that is it for today. I am told when I spoke with counsel earlier
What?
that we are still on track. I have to tell you those same cautions. Please do not discuss this
She's letting
case
them go
with anyone.
early? Oh.
Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be extra careful with your social media use. And also, I just want to remind you, next week, Thursday is a half day and Friday is a day off.
So,
All right, so we'll see you on Monday.
Please rise for the jury.
oh, perfect. That works out great. Friday is a day off. Thursday is a half day. Oh, Judge Bev. We on the same schedule. Shout out to Judge Bev. Wow, I can't believe that was it. We're done. That actually works out because I got some things going on Friday. Cool. All right, we're not done yet, though. Hold on a second, y'all. We got to skip ahead because it looks like she's back to give some further instructions. Here we go.
So before we recess,
I ain't mad
I
at it, God.
appreciate that counsel provided me
GOR.
with the information. Mr. Leslie, I got the 2 reports that you had that were incorporated and what the Commonwealth had given me a few minutes before, but I appreciate that it was pointed out here. We've had full argument on this yesterday and today. My findings for the record are that the
Next
defendant has
Friday.
not persuaded me of undue surprise or unfair prejudice by this information, and I don't find that there's delayed disclosure. Of course, all of this is ample game for cross-examination. Certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination, and I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on that. Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again.
Good.
But if after the direct you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well. So regarding Dr. Welcher, as my understanding, the request yesterday was for, and it's been a request, I think, a few days. We've addressed it at sidebar, and I found that it wasn't the right time. Let's see how much Dr. Welcher could go through. I understand Dr. Welcher will testify in the Commonwealth's case in chief like next week or so, Mr. Brennan.
Hopefully next week, if not,
All right.
the day after the holiday.
And that will be for all of the material that was provided to the defendant initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies the new information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right, so I would allow under these circumstances a limited rebuttal, and we can define the scope after we hear the testimony of ARCA. So those are my rulings. Your objections were noted. I'll see everybody on Monday.
All right, there it is. It's a light day. So next week, Thursday is going to be half day. Friday, we're not having court. And then y'all are saying next Monday, the 26th is a holiday? What holiday is that? That is Memorial Day. Cool. Arker. Shout out to Arker. We've got oh, hold on. Is it Janice? Is that how you pronounce it? Janice Lewis in here with the 10 bomb says, love your commentary since the YSL trial. Thank you so much, Janice. I appreciate you being here. Thank you for the support and the 10 bomb. That's funny. A lot of y'all are talking about YSL. I know Floyd was mentioning earlier, which one do I think has been more interesting, YSL or this trial? I think, as I said to Floyd, they've both been interesting in their own way. The YSL trial, I think we had a lot more back and forth between the defense and the prosecution. This, probably because it's the second trial, seems to be moving through a lot more smoothly, a lot smoother. And Judge Bev she's on a tight clock, so I like to see it, man. Shout out to Janice. Thank you for the love. Memorial Day and my son turns 22. Nana Banana says Indy 500 on Sunday. Ooh, nice. The clothes rode around in the truck for 4 days and he had the evidence. The evidence wasn't submitted to the lab for 6 weeks, guys. 6 weeks. Insane. Absolutely crazy. Bev wants a 4-day weekend. I ain't mad at it, man. Shout out to Judge Bev. I think I got all the super chats. Let me shout out everyone real quick. Shout out to Slim Life over on the PayPal. Dropped a 20 bomb over there. Les Cleaver, thank you. Amy, my awesome, amazing Amy's in here. Virginia Wiley, Teflon Don, CPE, Kara Hampton, Peter Ortiz, of course. Curious Coco, New York, Kim Dorsey, Mr. Brown, my guy, and then of course Janice Lewis. Thank y'all for the support. Thank you all for the super chats and going the extra mile to support the channel. Big thank you to all 1,600 of you that liked the video, which is insane. We're going to be dropping some more clips and reviewing some of the things that are going on in the Diddy trial as well as this trial over the weekend. So make sure y'all look out for that. If you haven't yet subscribed, hit the notification bell so you don't miss any time that we go live or drop a new video. We're also going to be live tonight for the Song of the Night Live. So if you guys enjoy music from independent artists and a lot of the independent artists who are in the community here, make sure you check out the show tonight. Shout out to my guy Peter Ortiz with one last super chat with the 2 bomb. He says Memorial Day is my and my fellows Veterans Day. Shout out to Peter Ortiz and thank you again for your service, man. I say this all the time. I respect and have so much love for our men and women who serve in the military. Thank you again to all of y'all who've served. I would not be able to do what I do here without y'all. It's pronounced Gene Ice. Gene Ice? Genus? Gene Ice? I don't know. I'm so bad with names. I'm gonna call you JL. Shout out to JL over there. Thank you for the love. I appreciate that. Let me make sure I didn't miss anybody. All right, it looks like we're good. Y'all have an amazing weekend. Hopefully I get to see some of you tonight. As always, you know what to do. Have a great rest of your afternoon. Keep growing, keep pushing, keep it classy.